Oh, that's fine.
Oh, okay. Yeah, that's.
I would say yes. No, can you see the witness stand from where you are, sir?
I can see the table, sir. I can see part of your head.
Okay. That should be that. Forward. Forward. It's going forward. I'm sitting here now. Oh, that's right. Yeah. I'm gonna move that. Yeah. Can you move down there? Yeah. They gotta move down this way.
Yeah. Okay.
Yeah.
It's something.
I have other questions.
You can see, you can see, Mr. Cybers can see, and even if we hadn't moved you, we'd still have to because you would have seen Jessica and not the witness.
I'm here.
Any issue for you with this, Mr. Ralston? Any issue with you with this?
Not at all.
Mr. Menzio, is this okay with you? Mr. Cyber?
No, Your Honor.
And you? Yep.
No, Your Honor, thank you very much.
Okay. Any other layout? If you guys need to move the mic, Jeff, go right ahead and do that. See, hold everybody, this will be fun. You guys are okay there? You're all right in that seat? I mean, it's not ideal, but it is what it is. Okay. You guys are set. Good with cords. You guys are going to fix that. That's mic'd up. And that doesn't.
To take a recess before the after open arguments.
Usually.
I like those odds.
It'll depend on how long it takes.
Right. You might want to put it right next to it. Sometimes that causes interference. Right. Just worried about. Yeah, like not to.
When you say it causes interference.
Nothing you mean. This is you're wired. These are wireless.
This is also wireless.
Oh, is it?
Yeah,
They're picking up on it.
it can, yeah. I don't have it turned on to do so, but it can. Should I, will that,
I don't think so.
can I also use this and this also?
You guys
All
are
three
set.
of them do.
Yeah, we're just debating what we'll do during lunch. We'll see if we can put it here, because I'll be referring to it. But we might be, yeah. Yeah.
We're going to take a break.
Okay. You know, I was wondering. And I can't really feel better. Yeah. Are there people who like specifically do order layouts?
I mean, yes and no.
That's when. Exactly. And now it's done. Yeah. Thanks.
Just so you could.
Very good, thank you.
You all, anything else, sir? Did you guys get everything just that you need to? Yeah.
All rise, please. The 13th Circuit Court for the County of Antrim is now in session. The Honorable Charles Hamlin presiding.
Thank you, you may be seated. All right, let's go on the record minute file 22-5165-FH, people of the state of Michigan versus Eric Molitor, Michael Null, and William Null. We can start out by having the attorneys put their appearances on record.
Morning, Judge. Bill Ralston on behalf of the people.
Good morning, Your Honor. Dan Grant on behalf of the people.
Good morning, Your Honor. Phil Johnson.
Christina Nanza on behalf of defendant William Knoll.
Amy Nunz on behalf of defendant William Knoll. Tom Sider on behalf of defendant Michael Knoll.
William Barnett on behalf of Eric Molitor.
Thank you all. The record notes you that the defendants are all present in the courtroom as well. I have a couple of things that I want to go over before we bring jury in and certainly allow the attorneys an opportunity to address anything that they want as well. The first thing is to welcome everybody. This obviously, for all of the mantra that I've had for staff and the attorneys for the months that have preceded this, to say that this is just like any other case. It certainly is not in terms of the attention that it has received, in terms of the number of people that will certainly be paying attention to it. But it is just like any other case, any other trial that's going to be conducted in the state of Michigan today, because we follow the same court rules, the same rules of decorum, the same rules of evidence apply. Doesn't matter what the charges are. If we're trying to retail fraud first case, it would be just the same exact process. And so as I told the attorneys from the first time that I spoke with them, this will not be a circus. This is not entertainment. This is to determine a very serious issue, and we will allow the jury to do just that. Everyone in here, no matter the capacity, is a professional. I I expect everyone to behave as such. We certainly have gone over the rules of what certain folks can do and what they can't do. I don't think I need to address all of those here. But we're going to keep this case in the lane, and we're going to stay between the lines. The attorneys have all been practicing for a long time. They certainly know what that means. They know how to do it that way, and I have no doubt that they will. One thing I will ask from them, there may be objections to exhibits, things that we need to discuss outside the presence of the jury. You all know that before I do. I will obviously be the one to make the determination as it comes to that, but if you do think it is something that we should discuss outside of their presence, if you could just give me a heads up so that I'm able to excuse them, and we can certainly do that. Obviously, for the folks that I will just group under the title of media, and everybody here, there is a live stream going to channels actually, as well as a third camera that may be recording, so please be aware of that. We've had multiple discussions with them. They know the rules of what they can and cannot do. There may come a time where, because of a certain witness testifying, for example, that someone may request that the video feed be turned off due to it being an undercover agent, for example. That's a determination that the court will make each and every time it becomes a request or is appropriate. Certainly, if the court were to rule that the video feed needed to be turned off, for example, that would obviously still include still photographs as well, so any visual would be blocked at that point. The other thing that comes with that, and the number of attorneys and everything else, are all of the cords in the courtroom, so it may seem simple, but please watch your step. There is a lot of stuff here, and I don't want anybody to trip and get hurt. Exhibits are going to be displayed on the screen. Is that generally correct, Mr. Wilson?
Yes, sir.
So they will be on this side?
Sorry?
They'll be on this side?
Yes, sir.
Okay. Because obviously everyone can see the witness stand has been moved so that all of the attorneys have a view of that individual, obviously. And if anything comes up in terms of movement, we can deal with that. The court did send to the attorneys yesterday the proposed set of what I'll refer to as initial instructions. That will be the set given to the jury after or during, I suppose, when the Chapter 2 instructions are being read by me. My general practice is not to give them that full stack because, quite frankly, 30 pieces of paper or whatever it would be, I don't think would be helpful to anybody. So what my normal practice is to give the jury 2.5, which is presumption of innocence, burden of proof, and reasonable doubt. Given the circumstances of this case, I would also propose giving them 2.22. That's the multiple defendants, and they have to consider the evidence and law as it applies to each defendant. And then the two instructions for the charges, 3.8.3a and 11.34. I did send those out, or had our staff send it out to the parties ahead of time. There were some objections made, especially relative to issues that we had discussed in the past. I understand all of those. Those are the initial instructions based on the fact that nothing has been presented yet that the court would propose. Obviously, if there are other instructions in terms of the final set that are requested by the parties, we'll deal with that at that time. And so I guess when I say, are there any objections, my first part of that is, are there objections to only providing these instructions as opposed to all of the Chapter 2s? And do you object to the language that was included in these from the court? Let me start with the people.
We don't have any objections to what the court proposes. We did ask for the court to include a more detailed instruction as to personnel. I think the court ruled on that before, and I think it would be appropriate to give that as preliminary instructions too.
Okay. Well, I think as with the other instructions that were requested by some of the other parties, given that no evidence has been presented and there's been no challenge to that, so to speak, factually, I'm not going to give that, I wouldn't give that instruction at this time. Again, if it becomes necessary in the final set, we can certainly discuss it with that.
And this is important because obviously how we handle opening. Does the court intend to give that personnel instruction, the definition of personnel being singular at the end?
If it were to become an issue where something else was presented to the jury so that there is an issue that needs to be clarified, yes. But the parties are, so for example, you are able to tell them that the definition of personnel can include oneself. If somebody else were to counter that, then it may become necessary to propose an instruction. Okay. Does that make sense?
Yes.
Okay. Mr. Nunzio, in terms of the set of preliminary instructions that were proposed by the court.
Your Honor, counsel had already submitted a proposed set of instructions of which the court had denied, so as, for purposes of the appellate record, we're continuing to object to those, so that the appellate record doesn't believe or show that we've waived our objection. If we concede or submit additional instructions, it could be deemed a waiver. So we're continuing on with our objection with respect to proposed instructions at this time. And just for purposes of clarification, follow up on Mr. Barnett's, Mr. Wilson, his statement. The personnel definition, is the court adopting the federal definition with respect to bringing others as well as including oneself in that definition, or is the court just?
I'm not adopting the definition from the federal system if that's what it is. I'm simply saying that in the state of Michigan, my ruling is that the term personnel can include oneself.
Can include, but the presumption is that can is following up on another element, that they bring other people and can include oneself.
Correct. I think the term personnel can include other people, but it can also include oneself. And it can be referenced as such by the parties.
Okay, and I use the federal definition because that's what the federal definition is.
Sure.
So, is the court entertaining any other objections at this time, or?
Let's deal with the instructions first, and I'll give each party a chance to address anything.
I think that's all we have. Thank you.
And I would note for the defense attorneys, I understand perfecting an appellate record. If objections have been made previously, meaning there's been motions perhaps, such as with the jury instructions, by saying you agree to or had no objections to this initial proposed set, I don't view that as a waiver. I think that those are maintained. We're not dealing with that issue specifically, but obviously if you want to put that just to protect it, that's perfect.
Thank you.
Mr. Cyber?
Yes.
In terms of the initial or proposed set. Okay. And Mr. Barnett?
Objection, I just want the court to know I did file my proposed jury instructions, just wanted the court to look those over, the court to follow them. Would like to join in Mr. Cyber, Mr. Nunzio's previous and current objections to the definitions, for example, everything that they filed relative, probably more in depth than my objections and the proposed jury instructions. They did basically, at least one of them, filed the same instructions that was typed in the motion that the judge has already turned down. But I just asked the court to allow me to adopt by reference their arguments and mine. And if the instructions you're looking at this morning are standard,
Okay. And all of those objections for all three defendants are maintained for the purposes of the record. I would also at this time order that witnesses be sequestered. That will apply throughout the duration of the trial. So no witnesses subpoenaed can be in the courtroom, listen to any testimony or anything along those lines until after their testimony has been completed and they are released from their subpoena. The one exception that I would make is one that we always do, which is for the investigator, which I understand would be Special Agent Kabula. Is that correct?
That's correct, Judge, and as well, this is a joint investigation. Detective Sergeant Carl Schmitz from the Michigan State Police is in the courtroom. Second order, hands raised. I'd ask that he be accepted too.
Okay. Any objection from the defense counsel on that?
No objection. No objection.
None. Okay. That will be.
I'm sorry. I left out Mr. Harris. Special Agent Harris from the FBI is also, was a partner and co-investigated this as well. We'd ask that he be accepted as well. He'll be running our audio visual. I don't actually anticipate him as a witness.
Okay. Based on those circumstances, any objections from the table?
No objection. No objection.
no objection.
And just for order and ease of the court, since you guys are seated now, that's the order the court's going to go in, just because it's easier, quite frankly, for me to remember. I already mentioned about the courts. Also, I think somebody asked at one point, I don't have any issue or objection if folks want to leave stuff in the courtroom. It is a public building. It's obviously locked during certain hours. This room will not be locked, however, so just take that into consideration. But certainly if anybody wants to leave everything rather than having to move in and out every day, that's perfectly appropriate. So, that is what I had to cover. Let me go to the parties. We'll start with the people. Mr. Ralston, anything for you before?
No, thank you very much, Judge.
Okay. And Mr. Nunzio.
Yes, Your Honor. It has come to our attention that obviously that the state is going to get into certain items of evidence, uncharged acts, that being conspiracy and potentially other crimes. The defense has not received, I've checked with everybody, if I'm mistaken, please, I'd have the state speak up immediately. We have not received any notice pursuant to MRA 404B, prior bad acts, with respect to uncharged acts, okay? And so that's the rule that governs the admission of evidence and how the court is to instruct a jury relative to uncharged acts and the like. And so, since we did not receive a notice pursuant to statute 14 days prior to today's date, or prior to jury selection, we're requesting and objecting to any uncharged acts coming in at this time. It governs uncharged acts, Your Honor, because they're going to be alleging that the defendant sitting here today conspired with Barry Croft and Adam Fox with respect to uncharged acts. Now, I don't know how the court's going to deal with that, but they are supposed to file by statute a notice under MRA 404B. And therefore, we're objecting to any testimony that comes in relative to any uncharged acts, prior bad acts. And as the court knows, under 404B, it goes to plan, motive, scheme, design, intent. Not to show propensity, but to show the elements that I've just indicated to the court. We have not received that notice, and therefore we're filing a formal objection orally here today to the admission of any uncharged acts that our clients are facing by virtue of witness testimony and evidence today. Thank you.
Mr. Sykes?
Judge, we would concur with brother counsel. We have 2 counts. That's it.
Mr. Garner?
I join.
Mr. Wilson, responsible.
I'd say that if they think that we're getting into that territory, an appropriate thing to do would be to rise and object.
Will any such possible material come up during opening statements?
No, I'm sorry.
That's not, I'm just checking.
Yeah.
Okay.
There's an intersection here too, obviously, the co-conspirator statement ruling
Sure.
the court's issued, so.
That's fine. Well, what we'll do at this point is, the objection is noted for the record. We'll table that until, 1 second, Mr. Sauer. We'll table that until possibly becomes an issue and deal with it at that time.
Okay, because it's an admission issue, whether or not the court will accept the testimony pursuant to MRA 404B. And it's uncharged acts. At some point in time, counsel, joined or unjoined by the rest of the layers up here, you're going to have to make a decision on how you're going to instruct the jury, because they're going to allege this giant conspiracy. We're going to hear ad nauseum, conspiracy. They haven't been charged with conspiracy, and they could have charged conspiracy, but they didn't. The fact of the matter is, at some point in time, this court's going to either have to give some form of instruction or a curative instruction regarding uncharged acts, because not to do so would be a violation of our client's due process rights to a fair trial.
And that's perfectly fine. I'm familiar with the rules of evidence and how they work. I'll cross that bridge when we get there.
Okay, fair enough.
Mr. Sauer, anything else?
Judge, just Mr. Ralston alleged to it, and you may,
I'm sorry, Mr. Ralston.
Ralston, I'm sorry, thank you. I have no offense. Alleged that he may go into co-conspirator in his opening statements, and that could be cause for a mistrial.
Mr. Burnett?
Can you approach that just for another separate issue?
Actually, we're going to take a short break. Back to the attorneys in chambers, please.
All rise, please. All rise, please, for executive session.
Okay, we can go back on the record. Reflect that I had a chance to talk to the attorneys and chambers. We covered a couple of issues that I think we need to discuss at this time. As I let them know previously, any issues that they have specific to any piece of evidence in particular, we can deal with it certainly at that time. So with that, anything else from anybody before we bring the jury in and we do opening statements?
No, sir, thank you.
No, thank you, Your Honor.
Mr. Sack?
No, thank you.
Mr. Wagner?
No, Your Honor.
All rise for the jury.
Judge Hanlon is number one, back row
Yes,
left. Okay.
so, welcome back, ladies and gentlemen. This is seat number 1. This is seat number 10.
Your third.
Juror number one is going to be the back row, first one.
And I just stayed down there.
Number one is
So juror number 1 is back here, juror number 10 is here. There should be 9 seats in the room.
1 through 9. So your first one is.
I need a lot.
Okay, the second one is the first one.
Go ahead.
1 through 9, 10 through 18. So
For
you
the
have-
folks in the back row, watch the, it is a rise, so be careful with the step.
You're the fifth chair of the back row. One through 9, 10 through 18. One is the first one. Yeah. It's 1 through 9, 10 through 18.
Okay, everyone may be seated. Welcome back, ladies and gentlemen. You'll be surprised by the end of this, how good you all get at that. You'll come in reverse order and everything by the end. You'll recall during the jury selection process, I explained your role as part of this. Obviously, there are a lot of people in the courtroom, given the nature of the case, that might not otherwise apply. You'll also notice that there are media and there are cameras. What I want to let you all know about are the protections that apply to you in a case like this. None of that will ever be pointed at you. No camera will ever show your face. No one will release your name as part of this process. There will not be any still photographs, anything along those lines. Obviously, the first job of the court is to ensure that a fair trial is conducted. Maybe 1B, because I don't want to describe this number 2, is the safety of everybody involved. Nobody more so than the jurors. Okay, so don't worry about any of that. Your job is to simply pay attention to the evidence in the case and then ultimately make a decision. Okay? I do want to let you know too, I see everyone is wearing their lanyards. Please, when you're on the campus area, that would be anywhere in the general vicinity of the county buildings, keep those on so that way everyone can identify you as a juror. That way they know not to talk to you and any casual conversations that may be going on And again, like I told you before, if you see folks, they may kind of duck away from you or turn away. That's nobody being rude. It's just they're following the same rules that apply to you, which is that they can't talk to you or have a good morning or hello or anything along those lines. Okay, so please don't take that personally. For today, what we'll do, we'll take a break at some point this morning and get you all a menu, or each of you a menu, I should say, and then you'll pick from that what you're going to have for lunch, and then it will be provided and delivered to you, so that way you have it at the courthouse, just to reduce the amount of time that you could be in contact with other folks and those kinds of things. But we probably won't do that every day of the trial, but certainly at the beginning, I wanted to do that until everybody sort of gets a feel for the mechanics of this and how it's going to work. Okay. There are some initial instructions that I'd like to go over with you. Members of the jury, you have been chosen to decide 2 criminal charges made by the state of Michigan against 3 of your fellow citizens. I will now ask you to stand and swear to perform your duty to try the case justly and to reach a true verdict. If your religious beliefs do not permit you to take an oath, you may instead affirm to try the case justly and reach a true verdict. So if you would please stand and raise your right hand. Here is your oath. Do each of you solemnly swear or affirm that in this action now before the court, you will justly decide the questions submitted to you, that unless you are discharged by the court from further deliberation, you will render a true verdict, and that you will render your verdict only on the evidence introduced and in accordance with the instructions of the court, so help you God. Thank you. Thank you. You may be seated. You'll also receive a written copy of some of the instructions that I am going to read to you. You may refer to them during the trial. Since no one can predict the course of the trial, these instructions may change at the end of the trial. At the close of the trial, I will provide you with a copy of my final instructions for your use during deliberations. The ones that you get today, and actually when we take a little break, they will include the elements for each of the charges. So if somebody is reviewing those, like I'll read them to you in a few moments, don't worry about writing those down or having to memorize them or anything along those lines. You will have the copies of those instructions so you can use them. Okay. Now I will explain some of the legal principles you will need to know and the procedure that we will follow in this trial. 3 defendants in this case are charged with the same 2 offenses. They are charged in count 1 with providing material support for a terrorist act. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant provided material support in the form of currency or other financial securities, financial services, lodging, training, safe houses, false documentation or identification, communications equipment, facilities, weapons, lethal substances, explosives, personnel, transportation, including any related physical assets or intangible property, or expert services or expert assistance to another person. Second, that when the defendant provided material support to another person, he knew that the other person would use that support or resources, at least in part, to plan, prepare, carry out, facilitate, or avoid apprehension for committing an act of terrorism against the United States or its citizens, Michigan or its citizens, a political subdivision or agency of Michigan, or a local unit of government. An act of terrorism is committing or attempting to commit the violent felony of murder, assault with intent to commit murder, assault with intent to commit great bodily harm, arson, or kidnapping that was or would be dangerous to human life and was intended to intimidate or coerce a civilian population or influence or affect the conduct of government or a unit of government through intimidation or coercion. Murder, assault with intent to commit murder, assault with intent to commit great bodily harm, arson, or kidnapping are violent felonies. You must decide whether the crime was or would have been dangerous to human life, and whether the defendant intended to intimidate or coerce a civilian population, or intended to influence or affect the conduct of government or a government through a unit of government through intimidation or coercion by committing one of these felonies. The defendant is also charged with a separate crime of possessing a firearm at the time he committed the crime of providing material support for an act of terrorism. To prove this charge, the prosecutor must prove each of the following elements beyond reasonable doubt. First, that the defendant material support for an act of terrorism, which has been defined for you. It is not necessary, however, that the defendant be convicted of that crime. Second, that at the time the defendant committed that crime, he knowingly carried or possessed a firearm. It does not matter whether or not the firearm is capable of firing a projectile or whether it was loaded. A firearm includes any weapon which will or is designed to or may readily be converted to expel a projectile by action of an explosive. A pistol is a firearm. A person accused of a crime is presumed to be innocent. This means that we must start with the presumption that the defendants are innocent. This presumption continues throughout the trial and entitles each defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. None of the defendants are required to prove their innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendants not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. A trial follows this procedure. First, the prosecutor makes an opening statement where he gives his theories about the case. The defendant's lawyers do not have to make an opening statement, but each may make an opening statement after the prosecutor makes his, or each may wait until later. These statements are not evidence. They are only meant to help you understand how each side views the case. Next, the prosecutor presents his evidence. The defendant's lawyers have the right to cross-examine the prosecutor's witnesses. After the prosecutor has presented all his evidence, the defendant's attorneys may also offer evidence, but do not have to. By law, the defendant does not have to prove his innocence or produce any evidence. If the defense does call any witnesses, the prosecutor has the right to cross-examine them. The prosecutor may also call witnesses to contradict the testimony of the defense witnesses. After all the evidence has been presented, the prosecutor and the defendant's lawyers will make their closing arguments. Like the opening statements, these are not evidence. They are only meant to help you understand the evidence and the way each side sees the case. You must base your verdict only on the evidence. My responsibilities as the judge in this trial are to make sure that the trial is run fairly and efficiently, to make decisions about evidence, and to instruct you about the law that applies to this case. You must take the law as I give it to you. Nothing I say is meant to reflect my own opinions about the facts of the case. As jurors, you are the ones who will decide this case. Your responsibility as jurors is to decide what the facts of the case are. This is your job and no one else's. You must think about all of the evidence and all of the testimony, and then decide what each piece of evidence means and how important you think it is. This includes how much you believe what each of the witnesses said. What you decide about any fact in this case is final. Part of your job in deciding what the facts of the case are is to decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness says. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a person's testimony, you must set aside any bias or prejudice that you may have based on the witness's race, national origin, or ethnicity, gender, gender identity or sexual orientation, or religion, age, or socioeconomic status. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Does the witness seem to have a good memory? How does the witness look and act while testifying? Does the witness seem to be making an honest effort to tell the truth? Or does the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias or prejudice or other influences that affect how the witness testifies? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all of the other evidence in the case? When it is time for you to decide the case, you are only allowed to consider the evidence that was admitted in the case. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I tell you to consider as evidence. Are not evidence. Only the answers are evidence. You should not think that something is true just because one of the lawyers asks a question that assumes or suggests that it is. I may ask some of the witnesses questions myself. These questions are not meant to reflect my opinion about the evidence. If I ask questions, my only to ask about things that may not have been fully explored. During the trial, you may think of an important question that would help you understand the facts of this case. You are allowed to ask such questions. You should wait to ask questions until after a witness has finished testifying and both sides have finished their questioning. If you still have an important question after this, do not ask it yourself. Raise your hand, write the question down, and pass it to court staff, who will give it to me. Do not show your question to other jurors. If your question is not asked, it is because I determined under the law that the question should not be asked. Do not speculate about why the question was not asked. In other words, you should draw no conclusions or inferences about the facts of the case, nor should you speculate about what the answer might have been. Also, in considering the evidence, you should not give greater weight to testimony merely because it was given in answer to questions submitted by members of the jury. I will give you all a little cheat when it comes to those questions because if you're like me, your memory, you might forget the question before the end of the questioning. So what I always tell people, you have pads of paper, I'll get to an instruction in a few moments that'll let you know that you're free to take notes in the case. What I would suggest to you is flip to the last page, write your question down, that way you won't forget it. Don't pass it in at that time, just simply write it down so that you don't forget. And then, once again, wait until the end of all the questioning. The chances are that one of the attorneys will ask a question that answers yours. If at the end of that, you still have the question, that's when you would raise your hand. They'll all simply ask before excusing the witness if the jury has any questions. And at that time, you would raise your hand and pass it down, okay? If you cannot hear something that is said or presented, or if you cannot see a witness or evidence, please raise your hand immediately. During the trial, the lawyers may object to certain questions or statements made by the other lawyers or witnesses. I will rule on these objections according to the law. My rulings for or against one side or the other are not meant to reflect my opinions about the case. Sometimes the lawyers and I will have discussions out of your hearing. Also, while you are in the jury room, I may have to take care of other matters that have nothing to do with this case. Pay no attention to these interruptions. You must not discuss the case with anyone, including your family or friends. You must not even discuss it with the other jurors until the time comes for you to decide the case. When it is time for you to decide the case, I will send you to the jury room for that purpose. Then you should discuss the case among yourselves, but only in the jury room and only when all of the jurors are there. You must not talk to the defendants, the lawyers, the witnesses, or anyone who may be connected to this case. This means that you may not speak to these individuals, even if it has nothing to do with this case. You should be very cautious about speaking to people because you may inadvertently speak to someone connected to the case. This restriction is necessary to avoid even the appearance of any improper conduct on any person's part. If anyone tries to discuss the case with you or in your presence, tell them to stop. Explain that you are a juror and you are not allowed to discuss the case. If they continue, leave. Report the incident to court staff as soon as you return to court. When the trial is over, those restrictions obviously no longer apply. When the trial is over, you may, if you wish, discuss the case with anyone. The restrictions I am about to describe are meant to ensure that the parties get a fair trial. In our judicial system, it is crucial that jurors are not influenced by anything or anyone outside the courtroom. Under the law, the evidence you must consider must meet certain standards. For example, witnesses must swear to tell the truth, and the lawyers must be able to cross-examine them. Because information obtained outside the courtroom does not have these safeguards, it could give you incorrect or misleading information that might unfairly favor one side. These restrictions start now and continue until I discharge you from jury service. It is your duty as a juror to decide this case based solely on the evidence you see and hear in this courtroom. You must not consider information that comes from anywhere else. This means that until you deliver your verdict, you must not read, watch, listen to, or receive any information, including opinions or commentary about the case, whether in newspapers, on television, the radio, the internet, or on social media platforms. You also must not research any aspect of the case during the trial. This means research using a cellular phone, computer, or other electronic device to search the internet, as well as research with traditional sources like dictionaries, reference manuals, newspapers, or magazines. You must not investigate the case on your own or conduct any experiments concerning the case, including investigation or experiments using the internet, cellular phones, computers, or other electronic devices. You must not visit the scene of any event at issue in this trial. If it is necessary for you to view or visit the scene, court staff will take you there as a group under court supervision. You must not consider as evidence any personal knowledge that you have of the scene. You must not share any information about the case by any means, including cellular phones or social media. This means that even if you are not discussing the case with someone else, you may not post any information about the case on social media websites or in any other manner. If you discover that a juror has violated my instructions, report it to court staff. You may take notes during the trial if you wish, but of course you don't have to. If you do take notes, you should be careful that it does not distract you from paying attention to all of the evidence. When you go to the jury room to decide your verdict, you may use your notes to help you remember what happened in the courtroom. If you take notes, do not let anyone except the other jurors see them during deliberations. Your notes will be secured during any breaks. Your notes will not be examined by anyone, and when your jury service concludes, your notes will be collected and destroyed. There is more than one defendant in this case. The fact that they are on trial together is not evidence that they were associated with each other or that either one is guilty. You should consider each defendant separately. Each is entitled to have his case decided on the evidence and the law that applies to him. You can see that we have chosen a jury of 18. After you have heard all of the evidence and my instructions, we will draw lots to decide which of you will be dismissed to form a final jury of 12. Possible penalties should not influence your decision. If you find any one of the defendants guilty, it is the duty of the judge to fix the penalty within the limits provided by law. I may give you more instructions during the trial. After all the evidence has been presented, you will hear the lawyer's closing arguments. Following the closing arguments, I will give you additional instructions about the rules of law that apply to this case. You should consider all of my instructions as a connected series. Taken all together, they are the law that you must follow. After my final instructions, you will go to the jury room to decide on your verdict. A verdict must be unanimous. That means that every juror must agree on it, and it must reflect the individual decision of each juror. It is important for you to keep an open mind and not make a decision about anything in the case until you go to the jury room to decide the case. You must not let bias, prejudice, or public opinion influence your decision. Each of us may have biases or perceptions about other people based on stereotypes. We may be aware of some of these biases, though we may not express them. We may not be fully aware of some others. Take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. I caution you again to avoid reaching conclusions that may have unintentionally been influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of the other jurors who may have different backgrounds and perspectives from yours. Ladies and gentlemen, we're going to begin at this time with opening statements. The people bear the burden in this case, so they will always go first. Mr. Walton.
Thank you, Judge. Good morning, everybody. Your sacrifice continues. We appreciate your willingness to serve. I think if you go back to Monday, it probably didn't dawn on any, it probably dawned on all of you rather that, you know, if you wanted to find yourself excused from the jury, you could have, you know, and each of you made a decision. No, I'm not going to do that. I'm going to serve. I'm going to, respond to that summons and come down here and listen to this trial. We're grateful for that. Okay. Whatever your verdict might be. So let's talk a little bit about what I'm about to do here. As you heard Judge Hamlin tell you, this is our chance to introduce you to the case. Think of it as a summary or roadmap of what we believe the evidence in this case will show you. Okay. Now, as I pointed out earlier, and as Judge Hamlin did this morning, what I say is an evidence. Okay. So you might be sitting there and thinking to yourself, well, you know, Mr. Ralston, how do you know what the testimony might be? How do you know what the evidence might be? How do you know what exhibits might come in? Well, as you're going to learn during the course of the trial, I think you were introduced to it on Monday a little bit. Both sides have the same materials, okay? Whether it be written reports, witness statements, prior testimony, recordings, photographs. We each share the same base of knowledge, if you will, okay? And that's how each side is able to intelligently prepare for trial, is by knowing what the evidence is and what testimony and exhibits are likely during the course of the trial. So let's get into it a little bit here. Terrorist attacks and mass shootings, they don't happen in a vacuum, okay? There's a buildup to these events. And after an attack, everyone hears about the signs, the warnings, the bits and pieces of information that people knew about, but didn't put together in time to stop it. That's what this case is about, ladies and gentlemen. It's about the buildup and the way that these three defendants were involved in that buildup to a terrorist attack. You know, we have laws in the state of Michigan that make it a crime to help someone who participates in that buildup. And those laws are called providing material support for a terrorist attack, okay? They cover a few rules of the road if we could. Judge just told you about the presumption of innocence, very important. The defendants, as we sit here this morning during the entire course of the trial, are presumed innocent. The burden of proof is on the prosecution. That's only fair. If you make an allegation, you should bear that burden of proof. Each element has to be proven beyond a reasonable doubt. Motive is not an element, but it's something you can consider when you think to yourself whether or not the elements have been proven, okay? And the reason that's so is because motive is, we talked a little bit during voir dire, there's not a lot in life that we do that's by mistake. And one of the things that I think that you'll see here during the course of the trial is that the defendants shared a motive and they all had a reason to help a terrorist. Court's instructions, evidence comes from the witness stand, any exhibits admitted during trial. You can use both direct and circumstantial evidence to prove an element to the crime charge. You know, direct evidence is I saw what happened. Circumstantial evidence is the raindrops on a raincoat and the man carrying an umbrella. Factors to consider in judging a witness's credibility: age, maturity, personal interest. Does the testimony agree with other evidence in the case? The defendants are charged with first providing material support for a terrorist attack, and to two individuals, Adam Fox and Barry Croft. You're going to hear those names quite a bit during the course of the trial. First element of this charge is that they provided material support to Barry Croft, and the judge just read this to you, and you can see it with your own eyes now, and you'll get written copies of this when you go back into the jury room at the end of the trial. But it's someone who helps another individual in some way, provides something that's material, okay? And for instance, take for example the word personnel. The judge is going to instruct you that if a person provides themselves to an individual, works with them and helps them and assists them towards a terrorist attack, that's sufficient to satisfy this particular element. And when they did that, when they provided that material support, they knew that the individual, Barry Croft or Adam Fox, would use that support in whole or in part for an act of terrorism. That is to plan, to prepare, carry out, facilitate, or avoid apprehension for an act of terrorism. Now, obviously, the definition of an act of terrorism is a violent felony, dangerous to human life, and intended to intimidate a unit of government or a civilian population. There's only two elements to the first crime. I mean, that's all there is. There isn't 7 or 8 or 9, as in the cake recipe analogy. Rather, there's only 2. For felony firearm, it's the same thing. Each defendant is charged with that felony firearm, and there's 2 elements that must be proven there before you could return a guilty verdict. One, that the defendant possessed a firearm and at the time he committed a felony, and the particular felony in this case is providing material support for a terroristic act. Let's talk a little bit here about why you're sitting here today. Okay, what brought you here today? And it's because of the actions of Mike Knoll, Bill Knoll, and Eric Molitor. And the defendants walked up to the edge of violence. The evidence is going to show you that they supported 2 terrorists, that's Adam Fox and Barry Croft, who were planning an attack against law enforcement here in Antrim County. Barry Croft and Adam Fox are the terrorists that Bill Knoll, Mike Knoll, and Eric Molitor helped. Just after COVID started in early 2020, Barry Croft initiated a plan to conduct attacks across the United States in multiple state capitals, targeting sitting governors. And you can think of Barry Croft as the national movement leader, if you will. Adam Fox was his Michigan commander. And you're going to learn about the civilian army that Adam Fox was starting, and that he was working with Barry Croft, and they shared a very common ideology, an anarchist, anti-government ideology. It's how they thought. Barry Croft posted on Facebook, "I believe all it's going to take is one state to burn out and hang a governor, and those dominoes will start to fall." And I think you'll see during the course of the trial, the evidence is going to show you that what he's talking about there is he wanted a multi-state, coordinated, simultaneous attack on sitting governors, including here in the state of Michigan. Their plan didn't just involve kidnapping the governor. Their plan involved a 20-minute free-for-all gun battle on Birch Lake and the murder of Michigan state troopers who were assigned to protect our governor. It's much more than just the governor, ladies and gentlemen. These men were helping Barry Croft and Adam Fox towards an end of killing law enforcement officers here in Antrim County, including members of the Elk Rapids Police Department and possibly members of your Sheriff's Department. You're going to hear audio recordings of the terrorists planning their operation with defendants' help. Here are 2 audio clips of Adam Fox in the car with Mike Knoll and Bill Knoll. And listen to Fox's plan to kill the local police officers. This case is much more than a kidnapping plot. Give me just 1 minute if I could, Judge. Dan, come here for a minute, I'm sorry. How do I, okay. Okay. Let me try it now. Here. Good. Good one. Yeah, sure. Judge, I'm having a problem here that I could use 5 or 10 minutes on. I apologize. I'm sorry.
All rise for the jury.
Thank you.
If you would retire to the jury room, then we'll bring you back out when we're ready.
Apologies. Yeah.
You all may be seated. Take your time, Mr. Wilson.
I'm sorry, Judge.
It's fine.
You know.
We all indicated many times there are things that are going to come up.
Yep.
It's fine.
First, let's close out with everything else. You don't need this, right?
No.
You don't need that.
Yeah. Yeah, I appreciate it. Thanks, Daniel. Yeah, close those out too. I don't need those. Is that what the spirit's crashing in?
I don't know.
My copy, everybody, please.
I'll go back. Where do you have your?
Rhino. Antrim. Okay.
So he should be.
All the way up. Get that bugger all the way up. Right here.
Yeah, hold on.
Okay. Okay, good. Part of it.
Let's go back and test this.
Yeah. Let's start on here. Let's start
You
the,
go down right here.
I lost presentation. Let's see. Okay, right here.
Hold on.
There you go.
Okay.
More. A little bit more. Okay.
Okay, so be right here.
Okay. Okay.
Yeah, there it is. It's
But it's all the way up here. This is good. I
I
don't care.
I would start with this one though.
Okay.
That other clip is quiet anyway.
Yeah. Okay. Good. Hey, thank you. I think we got it figured out. Can I hit the head for 2 seconds? Thank you.
Basically instructions of it.
Oh, yeah. You're really good about reading.
The other ones.
Yeah.
Too much coffee.
Yeah.
My default is gonna be an hour, but if you guys need 90 minutes, that's fine. I guess we'll have to see where we go.
Okay, sure.
Hey, Mr. Nunzio, I want to give you guys an opportunity. I know you have work to do, but I also want to give you guys a chance to actually eat food, as which we intended with lunch. So if we need 90 minutes, that's fine.
Okay.
Don't worry.
I don't think it'll be big. Maybe like in between, like, several times.
Sure. I mean, let's say it's 11:45. We come back at 1, stuff like that. We'll work on the clock.
Just curious.
That's fine. Cross the bridge when we get there.
Yeah.
Ready when you are, Judge. Thanks. Appreciate the break.
Good minutes, all the defense attorneys, you guys good? Mr. Olson, you have everybody?
Yes, sir. Yeah. Yeah, I can reach over and do it. I think it's a little busty.
All rise, please, for the session session.
Thank you, you can be seated. Okay, let's go back on the record. Mr. Ralston, technical difficulties, all set?
Think so, Judge. Okay. Thank you very much.
The record can also reflect that the jury is obviously still out of the courtroom, so we're going to take this opportunity. Any objections from any of the attorneys to the instructions as read by the court versus the people?
No.
Mr. Nunzio?
No, thank you.
Mr. Sagan?
What was the question, Judge?
Any objections to the instructions as read by the court?
No, Judge. Thank you.
Okay, I just want to make sure we got that. Thank you. All rise for the jury. You all can have a seat for a seat. You all can have a seat for a seat. We missing one? Somebody's telling me that's Western, that's perfectly fine. See, I told you, look how much better you were eating the second time.
Yeah. Yeah.
You're like this. Everyone can be seated. Thank you. Welcome back, ladies and gentlemen. In the agenda, two good things for me to remind you all of. If anyone ever needs a break, or anything like that, simply raise your hand. You all are the ones that are the most important ones in the courtroom. You need to be able to concentrate and see, hear everything. So if there's something that's going to interfere with that, simply raise your hand and let us know. We can take a break. The other thing is I see some folks without a bottle of water or something back into them. That's perfectly fine. If later in the day you want to bring a snack or something along those lines, that's all right too. Just make sure that whatever it is doesn't interfere with your ability to pay attention. Okay? Thank you. Mr. Wilson.
Thanks, Judge. I forget who the stage performer was from the 1930s or so that said he wouldn't work with animals or children. And before computers came out, I want to thank you for your patience. Judge, can I ask the first row of lights maybe be turned down a little bit so that they can see the screen a little better?
Mr. Arden, could you possibly turn down the lights if we can figure out what row is which?
Just the first row would be great. Over here. I think it's just a switch. Okay, yeah. Okay, yeah. Thank you very much. Returning to my remarks here, the audio recordings that you are hearing Some are very loud, some are a little softer. That's why you're going to have transcripts provided for you. Okay, it'll identify who the speakers are, and hopefully that will be of help to you. This second piece of evidence that we believe will be admitted during the course of the trial, I'll remind you, is Adam Fox, one of the two terrorists that the defendants were helping plot an attack here in Antrim County. And here's a conversation between Mr. Fox, or Mr. Fox rather, speaking to Bill Null and Michael Null, who were in a vehicle with him, and Mr. Fox telling both the Null twin brothers his plans about attacking the governor, state of Michigan, and her security detail at her cabin on Birch Lake.
You guys about coming to security jail, and I've heard that she was pretty she was on that one day for 1 year. So there was like one security SMB and then her SMB. So that's a pretty big detail. Maybe 4 or 6 weeks. He's gone for a week, basically short. Maybe she got 1 or 2 weeks. Okay, well, how many deal with those? Well, we do 2, 1, 8, 9, 10, 15.
Now, ladies and gentlemen, I want to remind you that these defendants aren't charged with conducting a terrorist attack or attempting to conduct a terrorist attack or communicating a threat of terrorism. I mean, they're charged with providing material support to another who planned the attack. Okay, so try to bear that in mind during the course of the trial. As we progress into the details of the attack, I think you're going to hear the why, or the motive as we call it, which behind the actions of these defendants. And right now I want to walk you through the significant events and the defendant's involvement step by step, and you'll see that really the facts of this case are rather straightforward. These are the 3 defendants, or rather the 3 threat streams, if you will, that came together plotting an attack here in Antrim County on the governor's cabin on Birch Lake, planning to kill her security detail and any other responding officers from the local area that came, including Elk Rapids PD and the Antrim County Sheriff's Department. The Wolverine, it's about 3 different threat streams coming together. The top is the Wolverine Watchman, and Adam Fox and his team, and Barry Croft and his team. Barry Croft was from Delaware. You might hear him referred to as the gentleman from Delaware. Adam Fox was from Grand Rapids, and the Wolverine Watchmen were based out of Jackson County. And all 3 of these groups harbored a strong anti-government, anarchist militia mentality, okay? And they referred to themselves kind of pirating or misappropriating traditional words, as they called themselves the new founding fathers, and the evidence will probably show you they considered themselves the patriots, okay? These 3 threat streams came together based on their shared ideology. I mean, they did not, as I mentioned, they didn't like the U.S. government, they didn't like state government, and they all desired a start to the Civil War, if you can believe it. They actually they wanted a civil war to come to the U.S. And you're going to learn a little bit about the code words they use. And they called this Civil War the Boogaloo, or the Big Igloo. Simply put, Barry Croft, who you see up there in that picture with Adam Fox, held a national meeting down in Dublin, Ohio, on June the 6th of 2020. And the purpose of the meeting was to bring people together from other states that were like-minded, who were in the Boogaloo movement, you'll hear, and to discuss the actual kicking off of a civil war in the United States by coordinating it and making it simultaneous, as I said earlier, in different states against different sitting governors. Barry, I'm sorry, the name of this meeting was the New Founding Fathers meeting, and Adam Fox attended, and so did Bill Null. Later in July, there was a training, or what they called an FTX, and that's short for Field Training Exercise. I mean, these defendants and the people they were trying to help, Barry Croft and Adam Fox, I mean, they considered themselves military almost. I mean, they had heavy weaponry and they were very serious about their business. This training in Cambria, Wisconsin was also attended by Barry Croft and Adam Fox, and it was used to help further the plan to attack Governor Whitmer. What you see is a daytime, in the daytime surveillance box there, is on August 29th of 2020, Eric Molitor and Adam Fox, with a confidential human source, an individual that was working with the FBI as their eyes and ears, traveled here to Antrim County on that date. And Eric Molitor, along with Adam Fox in the car, actually reached the threshold of the governor's cabin's driveway. Okay, they were here surveilling the cabin, because Adam Fox and Barry Croft wanted to kill the governor of the state of Michigan, and they were willing to kill her security detail to get to her. And this surveillance was part of what they called recon or reconnaissance of their target. It's what you'll hear that they called the governor. There was also a training exercise that was conducted south of Cadillac, which is the Michigan Field Training Exercise, just outside of Luther. There you see a picture of Mike Knoll, who was present during that training exercise. And that was held on September 11th and 12th of September. And this, the point of this particular exercise was, again, to help refine the plan to attack Governor Whitmer, to practice the skills they would need to assault her cabin and take her by force. Eric Molitor provided some specialized equipment for this training exercise to Adam Fox in the form of a radio frequency detector, which could be used to find listening devices on individuals who might be undercover agents or cooperators with the investigators for the case, recording devices, things of that sort. And it finally culminated with a nighttime surveillance on September the 11th of the governor's cabin here on Birch Lake in Antrim County. The second surveillance that was conducted on her property by Adam Fox. And on this particular evening, Barry Croft was also there, the second terrorist. The Knoll brothers were also present during this nighttime surveillance and assisted Adam Fox, okay, during the course of this nighttime surveillance of the governor's home. This is a video that you're about to see that was actually produced by the team that surveilled Governor Whitmer's cabin on September 12th. There were 3 operators in the car. And by the end of this trial, I think you're going to understand how this plot unfolded, how these defendants came to help Barry Croft and Adam Fox. I must say, though, that for the average person, it's almost impossible to fathom how brazen, how bold, and how dangerous these individuals were. These defendants decided to use force and violence to solve their problems.
petition file and time sheet green signs up there.
Let's walk you through the why a little bit. And the why and the motive, why the defendants believe they needed to resort to violence. For this, you need to know and kind of see how the defendants' anti-government ideology led them to believe they could start a civil war. So part of the evidence in this case is going to be their core identity, okay? And really what that goes to is intent, okay? It'll shed light on, we're going to shed light on their intent through their core identity. The defendants were using COVID as a reason to voice their hatred towards our government, and they weren't shy about it. They attended protests, which is legal, but they found very quickly that protests weren't enough for two reasons. One, their demands weren't being met, and also these defendants harbored a desire to inflict violence. Some of the evidence is going to be how these defendants used rallies and protests, in fact, to meet and recruit others in their plan in uniting for a common cause. Body of the evidence that I believe is going to be given to you is how these defendants created a team, if you will, and they participated in what's called encrypted chats, which means communications electronically that only the sender and the receiver can read, okay? And that's done to thwart, the possibility of being discovered. I mean, they knew what they were doing was wrong, and they used this means of communication to try to thwart anybody catching them. And finally, how these defendants use their skills, training, and equipment to come together as a team. The Wolverine Watchman was an anarchist militia that started during the fall of 2019, well before COVID started. The FBI and the Michigan State Police started a joint investigation into the group in March of 2020 after learning about some illegal weapons and offensive training they were conducting in Jackson County to attack law enforcement. The Wolverine Watchman is one of the three threat streams that came together and it ended up being here in Antrim County planning an attack on the governor over on Birch Lake and her security detail. These attacks were in support of the Boogaloo, which is again code for a civil war in the United States. On the right, you're going to see these are symbols of the Boogaloo movement that you'll learn about. They called it the Big Igloo. The Hawaiian-themed stripe in the middle that runs horizontally was their uniform, if you will, a way to, if you wore Hawaiian-themed and you went to one of these protests, people would know you were part of the Boogaloo movement. Two of these defendants, Mike and Bill Null, are 38-year-old twin brothers, and they were leaders in the Michigan Liberty Militia back in 2020, and they harbored anarchist views, and they publicly promoted the Boogaloo ideology. Now, these men weren't just preppers. I mean, they were not stockpiling beans and bullets. They trained to instigate violence, and they followed civil unrest. They traveled to bring violence to other places in Michigan, and they intended to start a civil war themselves right here in our state. And these are patches that they wore on their body armor. And you can see on the left, I mean, Bill Null had wasn't shy about promoting the fact that he was part of the Boogaloo movement. And on the right, Mike Null wore the same thing. Okay, let's talk about April 30th a little bit here. I think the evidence is going to show you that on that date, the Michigan House of Representatives was in session, and they were conducting an important vote on whether to support the COVID measures that were being promoted by the governor. Now, reasonable minds can differ. That's okay. And you can disagree with an elected politician. There's nothing wrong with that. But the Knoll twins led the American Patriot Rally on that date that was outside of our state capitol. And they made it pretty clear about where they stood when they were there. The Wolverine Watchmen also attended this rally. I mean, this rally was attracting this kind of group, okay? And they weren't there with the Knoll brothers, but members of the Wolverine Watchmen were. In fact, what you see here is a picture of the Wolverine Watchmen stacked up outside of the governor's ceremonial office in the Capitol. Now, the Knoll twins also entered the Capitol, and they went up to the second floor rotunda where the entrance to the House chambers is. And this event at the Capitol galvanized this boogaloo or anarchist community. And Adam Fox later told Barry Croft that they shook the halls during this day. Adam Fox was at the Capitol too that day. Again, these individuals haven't merged yet, okay? But they're beginning to. They're there. All three threat streams, except for Barry Croft, are at the Capitol this day. And you don't really have to wonder about where he's at and what he's doing. When you look at Adam Fox here and you hear what's going on in the Capitol, it's pretty plain. I'd also ask that you note his Hawaiian-themed shirt. And I'd suggest to you the evidence is going to prove that he's not wearing it by mistake. 18 days later, there's a second American Patriot rally over in Grand Rapids at Rosa Parks Circle. And Adam Fox, Eric Molitor, and the Knoll twins attended. Again, not together, but they're showing up at the same kind of event. But the short version is, ladies and gentlemen, is that these protests that they were going to, and they were using COVID as an excuse. I mean, they all harbored anarchist, anti-government view before COVID. And that's primarily what these protests were about. They were leveraging COVID to their benefit in the promotion of the Boogaloo movement and the desire to start a civil war. What these men believed, and the men behind me that are charged here, is that the people with the most guns who are willing to use violence should make the decisions, that they would be the deciders. Eventually, the Wolverine Watchmen and Adam Fox connect. And on the 20th of June of 2020, they meet in Grand Rapids, where Adam Fox works and lives at a place called the Back Shack. And Fox described his plans for violence and how he recruited the Knoll twins to these members of the Wolverine Watchmen. And he described the Knoll twins as being willing to die on behalf of the cause.
The Knoll brothers, Joe Smith, Larry, Mike, Bill Knoll, Bill and Mike Knoll, Bill came, but Mike didn't. But the Knoll brothers have a lot of faith in their knowledge. They're ready to talk stuff off. They're willing to attack with shit. They don't want to attack things. They don't attack a call with them.
Okay. What Adam Fox is talking about there is Adam Fox, if you recall, and Bill Knoll. And you don't have to remember every single event off of what I'm saying today. I mean, you're going to learn this through the course of the trial. I mentioned before there was a meeting down in Dublin, Ohio, the national militia meeting that was to coordinate, kicking off an attack in multiple states against multiple governors. And Adam Fox and Barry Croft were there. That's Adam Fox telling the Wolverine Watchman that Bill Knoll was there too. And they began to connect in the month of June of 2020. We're going to show you what the Knoll twins said and how they revealed their ideology while communicating with each other about using civil unrest with COVID to their advantage. Before COVID started back in November of 2019, this is a Facebook message by Bill Knoll. Fuck the police. They're the supporters. They're all the enemy, or they're all the enemies. That's before COVID even started. Mike Knoll, in March of 2020, posted that the fact that it will be the National Guard that's helping people is a pretty good indicator that it's kill or be killed. Bill Knoll on the 16th of March said, "No fear, Valhalla awaits its warrior." And you're going to learn a little bit that Valhalla is part of Viking mythology, and it's the Viking version of heaven. And in response to that message, Mike Knoll posted, "So I'm kind of excited." That's how Mike Knoll felt about the prospect of violence and another civil war. What you see here, ladies and gentlemen, is going to be part of the evidence in the case about operational security I mentioned earlier, or OPSEC, and how they used encrypted messaging and in-person meetings to avoid being detected. And this is a message from Bill Knoll, who says, who's talking about a meeting, okay, with other like-minded individuals in the Boogaloo. Set the time. The place should be in the woods we talked about last meeting. Leave all electronics at home. This is a perfect example of the operational security that Bill Knoll practiced along with his twin brother Mike, and also Eric Mahler. Okay, this is important because it tells you a little bit about the intentions of the defendants and the fact that they knew their actions were illegal. Eric Molitor's recruitment by Adam Fox was a little more personal. And Adam Fox actually got Eric Molitor a job as a private security guard. And Eric Molitor actually covered Adam Fox's shift, because Adam Fox was a private security guard too, when Adam Fox needed time off work to go to Ohio and Dublin for that national militia meeting where they talked about kicking off the Civil War with Barry Croft. It was called the New Founding Fathers meeting. You know, before the FBI, well, first of all, this is a post by Barry Croft. And the post is after Barry Croft has anointed Adam Fox as the commander of the 2nd Continental Michigan Regiment. And after he does that, Barry Croft posts this on Facebook, promoting individuals to join Adam Fox's group of anarchists. These following clips you're going to hear are between Eric Molitor and Adam Fox, and they are Facebook messaging clips, okay, that were acquired through a search warrant. Everything that you're going to see here was acquired through search warrants approved by a judge. These were not things that were, found or taken without judicial permission. Okay, nobody's rights were violated. The law was followed during this investigation. You're going to hear Adam Fox here messaging Eric Molitor.
All
Bro, that's not an issue at all. You'll have your own unit. We will be statewide. We're actually gonna be plugging out nationwide. We got this shit popping off, like right now in Delaware, there's a few other states. We're just gonna build a unit, like, you're gonna have your own unit, your own local community, and then we'll all get together, you know, like every couple months and train as a fucking state. We'll figure it out, dude. We're just gonna build a real fucking unit. No more social clubs, no more fucking ego tuning. Like, we're gonna build a real unit that's here. I don't know, we're not even gonna call ourselves a fucking militia, but we're just gonna be a civilian colony. Shut up! Fucking dogs. Anyways, man, it's gonna be righteous. I'm looking for people to grow. There's gonna be no chain of command. We're all gonna be equals. I want everyone's input. I want everything to run smoothly. The one thing I don't want is weak people who are uncommitted.
That was Adam Fox asking Eric Molitor to join his civilian army. This is Eric Molitor's immediate reply back to Adam Fox.
Bro, I just got goosebumps listening to that shit. That is everything that I want to fucking do. Exactly the way I want to fucking do it. I am 110% on board with this idea.
Eric Molitor was 110% on board. Here's the response from Adam Fox telling Eric Molitor, "You're part of it now."
Well, I'm fucking doing it, man. So it's just all part of it now. Now we just grow our shit. I got a meeting on Saturday out of state with some guys. So once after that meeting, I'll come back. Dude, we might be doing some real fucking cowboy shit here in the future.
The meeting out of state that he was talking about, if you notice, it's June 4th when that message was sent. June 6th is a meeting down in Dublin, Ohio with Barry Croft and the other state militia leaders that want to kick off a civil war. This is Adam Fox to Eric Molitor. Eric Molitor knew exactly what he was.
Calling ourselves Second Continental for a reason. George Washington's army was the first Continental. We are now the Second Continental. We're gonna take back what's ours, bro.
They saw themselves as the new founding fathers. That's an example of that. Here's a post by Barry Croft on the 15th of July where he says, and remember, he's the gentleman from Delaware. He's the national militia leader. At this point, militia resources should not be allocated for rallies and flag waving events. Total waste of good training time. Eric Molitor's response to that was, agreed. We tried it peacefully. We tried calling, writing, emailing. When our little protest didn't work, we all met up in Virginia, and we know how that went. No more rallies or protests. If it's time, it's time. We didn't make it this way. We were pushed and mocked. Done. By the middle of July, Eric Molitor had had enough. So the first event that brought these three threat streams together was Barry Croft's new founding fathers meeting in Dublin. They met in a conference room in the Drury Inn. Bill Knoll and Adam Fox attended this meeting. Listen to these audio clips and ask yourself, and it'll be very enlightening. I think the evidence will be in terms of what their intents were.
So we know you got to take action. There are levels of action, sharing the information, utilizing all those tools. I'm gonna go hurt people. I'm gonna go hurt people real fucking bad. And I apologize. I'm sorry. I'm gonna burn all the fucking houses down and flip shit up. I'm gonna do some of those nasty, disgusting things that you have ever read about. In the history of your life. I like it. Now listen, and I'm sorry for that. I really am. Well, no, because it's wrong. Because I'm in the episode community, and I have to break that poverty why. I've already asked permission. It's been crazy. I'm not worried about it anymore. I'm going to give it a second. If I fly through a motherfucker, burn it, full motherfucker family to the ground, knowing that I have one myself, I'm sorry. But I'm going to do it.
When Barry Croft made those statements, Adam Fox and Bill Knoll were in the room. And this is Adam Fox's response to that.
You can get along at the same time when you say, there you have value. And human life is the value, right?
Are they going to? No, I'm not mistaken, there's more lawyers, now we actually have from this delegate that we have that are very common.
What he's talking about there, when he uses the word tyrants, you'll learn during the course of this trial, that's kind of a code word for anybody from elected office or any public official or any law enforcement officer. This is Bill Knoll's response to after hearing both Mr. Croft and Adam Fox talk in that jury and conference room.
I did everybody there, so you were, I don't know if you were there on the day we went into the Capitol. I'm telling you, yeah, I went in there and I talked to the rally going to the Capitol. I haven't across the country. We walking place, walk down the Capitol. Doing something the first time coming. So I'm telling you, we make a plan, we need to make that.
We make a plan, we need to make a network, okay? The threat streams are coming together now at this point. Shortly thereafter, you're going to hear about CHS Dan, rather. And the FBI learned that Adam Fox was attempting to acquire explosives. And let me back out for a little bit here. CHS Dan is short for confidential human source. Okay, and Dan is going to testify for you. He's a gentleman who is an Army veteran. He has served our country. He worked for the U.S. Postal Service as a contractor in delivery of the U.S. mail. And he found the Wolverine Watchman on Facebook and was allowed to enter one of their private chat rooms after he was vetted, and immediately identified the fact that he had probably entered something he didn't want to get into because he saw they were talking about killing law enforcement, and they saw that they had illegal weapons. Contacted an individual in his local community who was a police officer who referred him to Special Agent Henrik Impola, who's going to be one of our witnesses. And CHS Dan became the eyes and ears, if you will, of this investigation early on. Now, during the course of the investigation and going into the summer of 2020, Adam Fox began to express a desire to acquire explosives. He actually wanted to blow up the bridge, the Elk River Bridge in Elk Rapids. And the reason he wanted to do that is because he believed that would slow down the police response to his attack that he had planned on the governor's cottage and on Birch Lake. Okay? And obviously, during the course of this investigation, the investigators from the FBI and the Michigan State Police, the last thing that they wanted Adam Fox to do was to actually get a hold of real explosives. And Adam Fox was talking about the baker that he was going to get these explosives from. The FBI inserted an undercover agent, and you're going to hear from Undercover Red, into the investigation, and the reason they did was twofold. One, Red was brought in under the guise of, oh, I'm an explosives guy, I can get you explosives, okay? Now, if he's Adam Fox's new explosives contact, law enforcement and the investigators know that Adam Fox will never get explosives through Red because he's obviously a sworn law enforcement officer. The other thing Red does is he gives a little more coverage to the investigation, if you will, than what CHS Dan was able to do as a single person. Here is an audio clip of Undercover Red being recruited by Adam Fox on July 3rd, 2020, the first day that Adam Fox met Undercover Red.
That's why I try to tell all my men to get them mentally prepared. Like, you have to be prepared because of what they're going to do. And if we don't do now, we don't act. It doesn't matter. In a matter of months, we'll all be criminals anyway. We'll be criminals because we want to keep our rights. And us wanting to bear arms to protect all of our constitutional rights is going to be construed as being criminals. So we're going to label those criminals months.
Right
when criminals, as long as we stay within the bounds of the Constitution, we will not be criminals. We will only be criminals in the eyes of their unjust, unconstitutional laws.
100%.
In the eyes of my God, I will die a fucking saint.
100%.
Hallelujah.
Adam Fox was fairly plain spoken. The Wolverine Watchmen and the Knoll twins attended a national training exercise in Cambria, Wisconsin that I touched on. They were invited to attend by Adam Fox, and the field training exercise included live fire weapons training, breaching and clearing a kill house, and combat medical care, not first aid like CPR or if you've cut yourself, what to do in the event that a person was shot. The FTX was actually a cover for Adam Fox, and he attended. And Barry Croft, he attended. And the Knoll brothers attended too. And it was a cover for them to do a couple different things. One, recruit, and two, continue to train in anticipation of the attack here in Antrim County, and to refine their national attack planning. And you're going to see in this next video Mike Knoll working hand in hand with Adam Fox in a maneuver sometimes referred to as leaping and bounding, while one individual shoots and pins down the adversary with gunfire. His teammate moves to a position of tactical advantage. My apologies. We'll get to that in a moment. During the training, Barry Croft announced that they'd be targeting Governor Whitmer in Michigan.
Quick, precise grab on that fucking government. And all you're gonna fucking end up having to possibly take out is her arm. With her arm drawn. All you're gonna have to possibly.
Okay. I'm going to stop here for just a second and point something out. I think the testimony is going to be there's over 150, close to 160 hours of recorded evidence in this case. Okay. We have selected what we believe to be relevant portions of those recordings of the different individuals that are part of this investigation for you to listen to. Okay. If anybody believes that we have taken anything out of context, they're allowed to, the defense is, put in what they believe fills in any gaps. Okay. So if anybody tries to tell you that we're cherry picking,
Objection, Your Honor. Bird shifting. Objection.
The attorneys all approach, please. All right, let's go back on the record. The objection, as I understood it, is burden shifting. Is that correct, Mr. Nunzio?
That is correct, Your Honor.
Mr. Stafford, you join in that objection?
I would join.
Mr. Barnett?
For the record, yes.
In response, Mr. Ross?
I don't believe it is, Judge, under the rule of law, the rule of completeness, which is a rule of law. They would be allowed to correct anything that if they think that I'm misrepresenting anything to the jury.
Well, ladies and gentlemen, let me take this opportunity to let you know a couple of things. There are rules of evidence. You'll hear those referenced. You may hear an objection followed by a number, for example, that would be tied to a particular rule of evidence. The attorneys certainly can do that. It's perfectly appropriate, as was just done by Mr. Nunzio, joined by the other defense attorneys. Then what happens is the other party, whether it's the prosecutor or one of the other defense attorneys, would be allowed a response. In this case, the objection is burden shifting, so I want to be very clear. I'm going to overrule the objection. What Mr. Paulson was talking about is some of the interaction for the rules of evidence and how they apply. But I also want to be very clear with all of you. You heard me say in the instructions, and it will be in the final instructions again. The defense attorneys and defendants do not have to prove anything. They don't have to prove their innocence. They don't have to, quite frankly, do anything. Everybody sitting at those tables could just sit there the entire duration for the trial. You could not use that against them. In fact, let's say one of the defendants doesn't testify, let's say none of them testify. You will be specifically instructed. That is their constitutional right, as it would be for all of you, as it would be for all of us. And you cannot use that or hold it against them in their deliberations. So I want to be very clear about the distinction. What Mr. Ralston was simply referring to are the rules of evidence and some of the ways that they interact. It does not shift the burden to the defense. They do not have to prove or do anything. Okay? Thank you. With that, Mr. Ralston.
Thank you, Judge. This next clip you're going to see here is during the training, our team members practice that movement under fire. And this is Mike Knoll and Adam Fox working together.
Wait, something. I'm not ready. Good. Lights out, baby. Love it. Just sing this song.
Evidence is going to show you, ladies and gentlemen, that these men were serious about their business. They had serious weapons. They had the ability to do what they wanted to do. That was at the Wisconsin field training exercise in July. Again, Barry Croft attended it. We see him here in his what they call kit with body armor, his long gun, his sidearm, multiple magazines. While they were there, and while Barry Croft was there, and Adam Fox, and the Knoll twins in Cambria, Wisconsin for this FTX. Barry Croft, along with the Wolverine Watchman members who you see on this picture, Mr. Croft on the right, two Wolverine Watchman members on the left, attempted to assemble a improvised explosive device with shrapnel inside it to test its destructive capabilities. Although it didn't work very well, you're going to learn during the course of the trial that Mr. Croft's skills improved. And this audio clip here is his 10-year-old daughter approaching them while he was making explosives.
Well, honey, I'm making explosives. Can you get away from me, please? Yeah, thank you. Some things you just can't do with pots, you know?
Barry Croft, you're going to learn through the evidence of this case, took his mission to kick off the Boogaloo or the next Civil War very seriously. Here we have Mike Knoll in 26th of 2020. He posts on Facebook, Civil War getting closer every day. Closer and closer every day. Okay, let's talk a little bit about the daytime surveillance. Again, this happened on the 29th of August of 2020, and CHS Dan and Adam Fox picked up Eric Molitor in Cadillac, and the governor has a protection detail of very dedicated Michigan state troopers who are sworn to protect her, and if necessary, give their life in pursuit of that goal. So I mentioned they got to the edge of the governor's driveway. When they got to Antrim County on this daytime surveillance, they wanted to make sure, the investigators to this case wanted to make sure that they had some control of the environment, that if Adam Fox or Eric Molitor wanted to conduct the attack that day, that they would have some ability to limit that. And so they told CHS Dan that he would have to drive, and that if anything happened, like if they were pulled over by the police, just on a chance encounter, Dan was instructed, you make sure you comply with the officer's requests, and you do everything you can to limit their desire to conduct an attack on that day. The invitation from Adam Fox to Eric Molitor to participate in this surveillance was done through electronic communication. And this was learned by the investigation actually after the investigation concluded with the arrest of the defendants, okay? The point that I'm trying to draw you to here is when Adam Fox and CHS Dan pick up Eric Molitor in Cadillac in June, none of the investigators, knew who Eric Molitor was. It was a new person that was entering the subjects of the investigation stream, if you will. So the invite was 2 days before, hey, want to go for a ride Saturday and do some recon? We're doing some recon on an Alpha Fox's, Adam Fox's handle. We're doing some recon on a high-profile vacation house. And he says, okay, well, we may get pulled to Detroit, and this was for some other protests that were going on. Just us with the boys. OPSEC reasons, cash for food. They didn't want to leave any electronic footprint. Low profile, no trail of our existence there. The day before, Adam Fox says we have 3 locations. We have intel on 3 already. We're knocking out 1 and 2 tomorrow. Adam Fox had 3 potential targets. You're going to hear about those during the course of the trial. 1 was the governor's residence in Lansing. 2 was the governor's residence on Mackinac Island. And 3 was the governor's private residence on Birch Lake. Correctly, that would be the easiest place to do what they want to do. They would meet the least resistance. Okay, the daytime surveillance. When Molitor was picked up by Fox and CHS Dan, he was immediately told of the plan to surveil the governor's cabin here in Antrim County. And during that surveillance, Molitor stated that he'd not be willing to participate in rape or torture of the governor, but suggested the location of local law enforcement, like those officers down in Elk Rapids, about 3 miles away, and other law enforcement agencies that might try to stop them. Adam Fox sketched a map of the Birch Lake area during the course of the day, and the neighborhood around Birch Lake. And they identified a neighborhood actually over on the bay that gave them Lake Michigan access. They talked about how they could use that point of entry onto the water to actually extract, was the word they used, their target onto Lake Michigan. While conducting the surveillance here in Antrim County, after being told what the target was, Eric Molitor actively participated and contributed to Adam Fox's plans after learning the governor was the target. Molitor performed 6 separate Google searches from his phone, searching for the governor's address on Birch Lake. During the surveillance, they eventually find the governor's cabin on Timber Lake Drive, which is basically a north-south dead-end street, runs along the west side of Birch Lake, okay? And she's actually, and she's closer to the south end of it. And when they found it, Adam Fox wanted help from Eric Molitor, and Eric Molitor provided it. Adam Fox handed Eric Molitor his phone and asked him to take a slow motion video.
One more time. Dedicating the family member. Do slow-mo video real quick, put this up against that window over there, and then press that button, do a slow-mo video as we go by there.
This is just set to do so.
It's on somewhere, I'll hit the button, and then it'll start shooting record. It'll be like a slow-mo video as we go by.
And here is the video that Eric Molitor shot for Adam Fox. Let me back out here for a little bit too. The evidence is going to show you during the course of this trial that people who work as a group together as a team, they're a more formidable adversary. They're more dangerous, okay? And it's not just one thing that any individual may do. Like, Eric Molitor is taking the video for Adam Fox there. I mean, he's providing material support. That's what the evidence is going to show you right there. He's providing material support by being there. There's a thing that we think about, I'm going to give you moral support. Well, you know what? When you show up and you stand next to somebody, even if you don't say a word, that's a form of providing material support to somebody. I mean, we've all done it. We've all gone to funerals. We've all gone to the hospital. We can't talk to the individual. And, being there as a member of the team and in support is a form of material support in personnel. You can provide yourself as personnel. Okay, during the surveillance, they identified the Elk River Bridge. They identified the Elk Rapids Police Department. What you see there is actually the truck where Adam Fox and Eric Molitor are in with Dan, and they actually drove by on Molitor's suggestion, the Elk Rapids Police Department. Okay. Let's talk a little bit about the Michigan FTX field training exercise down in Luther. The Wolverine Watchman provided a remote hunting property in Luther, just south of Cadillac, for this regional FTX for people from other states also. And the Wolverine Watchman invited Adam Fox and Barry Croft, who both attended, as did the Knoll brothers and as did Eric Molitor. And the point of this FTX is kind of an extension of what happened in Wisconsin. They're continuing to practice their military skills, and they're continuing to refine their reconnaissance and their attack plan on the governor's cabin here in Antrim County. Adam Fox invited members of his team, including the Knoll brothers, through Bill Knoll, to participate in a nighttime surveillance. Now, undercover agents and CHS Dan were there during this FTX, and the Wolverine Watchman actually worked for several weeks to prepare this property. I mean, they created, we'll show you evidence, they created a shooting range. They had a kill house that was meant to help them practice entering the governor's home and killing her security detail. And this was all in preparation for the attack on Governor Whitmer's cabin. This is a video here of Bill Knoll enters first, and then you'll see Mike Knoll follow on, and towards the end, and they're entering the kill house, which is made up of their blue tarps, and so that they have a feeling of a room and hallways, and they can practice how to enter and use offensive military tactics, essentially. During the course of this FTX, Adam Fox, Bill Knoll, and Mike Knoll trained with firearms. I mean, remember, felony firearm is one of the charges, not only providing material support for a terroristic act, but also having a gun when doing so. Eric Molitor, during the daytime surveillance, had a pistol with him. You're going to hear testimony about that. During the Saturday training in Luther, the Michigan FTX, if you will, Adam Fox pulled aside Bill Knoll and undercover Mark and told him about his plan to conduct nighttime surveillance on the governor's cottage on Birch Lake that night. And Bill Knoll was on board. Mike Knoll was not present for this particular conversation, okay? And Fox identified Governor Whitmer as the target. The point that we talked about on Monday, that actions speak louder than words. Although Mike Knoll wasn't present for the invitation by Adam Fox to participate in the nighttime surveillance like his brother Bill was, when it came time to that evening to go to the nighttime surveillance, Bill Knoll didn't show up by himself. He showed up with Mike Knoll. I suggest to you the evidence is going to show you that Mike Knoll knew exactly what he was getting into. Let's turn to Eric Molitor for a minute here. Eric Molitor had this radio frequency detector, okay? And what this thing does, I mentioned it before, is if you have a listening device or recording device on your person that emits, a radio frequency of some type, this device will find it. It will, and if you're an undercover special agent, or if you're somebody like Dan who's trying to, help an investigation, and you got a listening device on you, this can be a very dangerous piece of equipment. This is highly valuable to Adam Fox, and you're going to see here, Adam Fox didn't ask once, twice, but rather 3 times for Eric Molitor to bring his radio frequency detector to this FTX that happened in September in 2020. Bring your security toy to FTX, please. We need to use it. Hey, make sure you bring that scanning device, bro. That's 2 days later. And then the September 11th, the day before the nighttime surveillance on the governor's cottage. What's up? We're on our way now. Going to need that device you have tomorrow morning in Walmart parking lot. Barricade, that's Eric Molitor's handle. See you there. He doesn't have any objections. This is the device itself. And you can imagine that if you were an undercover special agent in an investigation, or somebody like Dan, who's just a civilian trying to do his part, seeing something like that would not be a happy day for you. They used it, in fact, to scan participants during the FTX. Okay, Barry Croft, Eric Molitor. Eric Molitor just didn't bring himself. He didn't just bring his specialized equipment in the form of radio frequency detector. He also brought a pretty unique skill set. He fancied himself as a very serious medic, okay? And medics in combat environments are a little bit different than the paramedics who might come to our home if we have a medical emergency. They're trained similarly, but they have different tools. They have things that are called Israeli bandages and deep compression bandages and things to treat combat injuries like bullet wounds or knife wounds, okay? Not the typical, I burned myself in the kitchen and I have an issue. Eric Molitor provided himself as a medic during this field training exercise in September. This is the field training exercise when the nighttime surveillance was conducted. And he provided himself as a medic during the kill house exercise that you saw a little bit ago. He stood by with his medical kit and was ready to, lend aid if necessary. And he also provided himself as a medic on Sunday. Remember, Barry Croft was up in Wisconsin trying to put that IED together, an improvised explosive device. I showed you that clip with the daughter coming up and saying, "Daddy, do you want a Dorito?" That one didn't work very well. When he got to Luther, he had figured it out. The device that went off at Luther worked. Okay, it was a significant explosion. You're going to hear testimony about that. Okay, let's talk a little bit about the nighttime surveillance. Fox assembled his team, and they all went to the Cadillac Walmart. Okay, because remember, they're in Luther, they're south of Cadillac a little bit. Now, Eric Molitor didn't go on the nighttime surveillance up to Elk Rapids and here in Antrim County. He participated in the FTX that weekend, but he didn't participate in the actual surveillance itself. And he arrived at the Cadillac Walmart, though, and the reason he did was because he had his radio frequency detector and Adam Fox wanted to use it on the nighttime surveillance. And so Eric Mahler actually drove up to Cadillac and provided that to Adam Fox, and they used that evening. They were in 3 vehicles. They came up here to Antrim County from Cadillac, and they stopped at the American Veterans Post in Elk Rapids there, just south of the bridge, west of 31, next to the Easy Mart. And Fox, when they got there, the 3 cars, Fox handed out team assignments. One car was to go down the governor's street, and while doing so, flashing its lights, called that the signal car. Another car was going to be a spotter car, and they were going to go to the north end of Birch Lake where there's a public boat launch, and they were going to see if they could see the flashing of the lights of the signal car, because then they could get an orientation on, because their plan was to go in by boat. So they'd be able to get an orientation of where the governor's residence was on the lake. And then finally, the car that the Knoll brothers were in was a counter surveillance car, or a surveillance car, or a lookout car. And what their mission was that night, essentially, was to make sure that if a state trooper, a regular patrol officer, or a county deputy sheriff was in the area, they could communicate to the other 2 cars about that threat to them. Undercover Red participated in this. And this next clip you're going to hear is Fox talking to the Knoll brothers as they're sitting in the Walmart parking lot down in Cadillac before they drove up to Elk Rapids.
This gentleman separates. Everyone else is sitting in the fucking parking lot at 10 o'clock at night on Saturday night. Who ain't gonna go do recon? Does anybody go do recon anything? Fuck no. We don't tons of it in the past, like, go fuck yourself.
This is Fox talking to the Knoll brothers about that little town of Elk Rapids.
It's a deep about the old place. Recon for the residents on hand. And so we done, but more or less, we got a very heavy security detail there. A lot of fucking spies. You're not going to know where they're staged, okay? 2 is potentially being with the fucking close friend. Here, it's a little town right there. There's a little bridge that goes over. We can blow that fucking bridge, and there's like no way for the cops to get around everything. It goes from the sides that are like 20 plus miles in all directions. Okay? So it gives us maybe a 15, 20 minute head start. And by that time, you can have the bitch in the fucking boat. You know, fucking thing.
That's one of the 2 men that Bill Knoll and Mike Knoll and Eric Mahler were willing to help. Placement of explosives under the Elk River Bridge. Undercover Red is now there at that FTX. He's been introduced as part of the investigation. He's the person that, I'm your explosives expert, I'll get you what you need, but I'm never going to deliver it to you, actually. That's how they made sure that Adam Fox wouldn't get any real explosives. Okay, well, he's up there with Adam Fox, and you all know the Elk River Bridge. And that's a picture of Adam Fox under the Elk River Bridge, taking a picture of the support structure. And this is from Undercover Red, who took a picture of Adam Fox taking a picture of the bridge. And this is how serious Adam Fox is. At just about midnight on September the 11th, 2020, he's climbing around underneath the Elk River Bridge trying to figure out where he put his explosives. That, ladies and gentlemen, is how these defendants ended up conducting surveillance on Adam Fox and Barry Croft, with Adam Fox and Barry Croft on Birch Lake here in Antrim County. What they didn't know was that the Elk Rapids Police Chief, Dave Centella, lived 3 doors south of the governor. in her house on Birch Lake. And in fact, when they went down the street here, they actually drove by Dave's house. And it's a location they passed on their nighttime surveillance.
Well, here's some fire alarm numbers, these green signs up here.
Okay. Again, you can tell a lot by what a person does. Okay. Actions speak louder than words. And, Eric Molitor, I've told you a little bit about what his contributions were to this plot of Adam Fox and Barry Croft to kill our governor and the state troopers protecting her, and anybody from the Elk Rapids Police Department or the Antrim County Sheriff's Department who came along and tried to stop him. Okay. And these men were about serious business. But that wasn't just enough for Eric Molitor, because Eric Molitor actually wanted to go down the line of succession, if you will. In the state of Michigan, just like in the U.S., we have a governor, and if God forbid something should happen to sitting governor, then the lieutenant governor is there to step in, much like the vice president does. That's part of our Constitution. And after the Luther FTX in September and the nighttime surveillance, he's trying to figure out who the sitting lieutenant governor is. And I suggest to you that the evidence is going to show you the reason he's doing that is because once they get done with Governor Whitmer, they're moving on to the next one. Again, these men wanted to be the deciders. Okay, at the end, they wanted to be the ones who made the decisions because they had the most guns and they were willing to use violence. Okay, almost done here. Let's look at the Knoll brothers and their actions. They traveled to the new Founding Fathers meeting, Bill did rather, down in Dublin, Ohio on the 6th of June. They practiced operational security. They were religious about it. They attended the Wisconsin FTX. Remember, Barry Croft and Adam Fox were there too. And they trained in Cambria with both. They went to the Luther FTX again, where Croft and Fox were at, and members of the Wolverine Watchmen. This is the three threat streams coming together. Okay. The nighttime surveillance, it furthered the plot to kidnap Governor Whitmer, and it furthered killing law enforcement, which they weren't afraid to do, and it furthered the idea of the demolition of the Elk River Bridge. They were going to be operators on Adam Fox's team. Okay, they were supplying themselves. Molitor's actions, he covered for Fox's work shift when Fox went to Barry Croft's new Founding Fathers meeting down in Dublin. Knowing what he was going for. You heard the audio clip. He practiced operational security too, and was very adamant about it. He participated in the daytime surveillance directly, armed with a gun. He came here to Antrim County to help Adam Fox surveil the governor's house during the daytime, and took the slow motion video that I showed you, and also proposed refinements to the plan of how they were going to attack the governor. He went to the Luther FTX. He provided that radio frequency detector to scan participants, and he scanned people himself. He acted as a medic in those two environments I described. He also provided his RF detector to Adam Fox for the nighttime surveillance. And finally, he was acting as the medic on Adam Fox's team. So let's real quickly look at providing material support again. I think at the end of this trial, you're going to be convinced beyond a reasonable doubt that these defendants provided that material support to Adam Fox and or Barry Croft in the ways that I've described here for just a little over an hour. And they knew what the plan was about, ladies and gentlemen. It wasn't like they gave somebody $100 because it looked like the guy was down on his luck. They knew what Adam Fox and Barry Croft were all about. They knew that those two individuals would use that support to help them plan for the attack on the governor and her security detail and anybody else who responded right here in Antrim County. There's no doubt that this was going to be an act of terrorism. Felony firearm has only two elements too. And again, that they possessed a firearm, or that they committed the crime of providing material support for a act of terrorism. And when they did so, they had a weapon. You've been very kind, very patient, listening to me, and that means the world to me, and I thank you. Not a word I've said is evidence. I've shown you what I think is going to be some of the evidence in the case. I mean, there's going to be north of 200 exhibits here. We're going to move through them one at a time, one question at a time, one answer at a time. We're going to respect your time. We're going to try to get through it as efficiently as possible. And I'd ask that you pay close attention. And when we return here for closing arguments, I'll be asking you to return a guilty verdict. Now, it's not required, but if the defendants want to make an opening statement, they can. And I'd ask that you give them the same kind attention that you've given me this morning. I appreciate it very much. Thank you.
Great, thank you, Mr. Wilson. We're going to take a short break. And while we do that, ladies and gentlemen, we're going to give you some menus from which you can select the lunch that you would like. And so we'll go take a short break. While you do that, I'm guessing it'll just be a quick one, 5 to 10 minutes. But obviously, feel free to use the restroom, all of those things. And the other thing is, when Mr. Gardner or anybody else knocks to see if the jury is ready to come back in, if one of you could just let us know. If somebody's in the restroom, what we're looking for is if all 18 are ready to go. And so if somebody needs another minute, just let us know that so that way everybody can come back in. Okay, thank you.
All rise for the jury.
Okay, you can be seated. The record can reflect that the jury is out of the courtroom. Let me just start with you, Mr. Nunzio. Obviously, the defense attorneys have the option of giving an opening statement, or you can reserve it. Let me begin with you. Do you intend to give one this morning?
Christina Nunzio intends on doing opening this morning, Your Honor.
Okay. And Mr. Simon?
Judge, I'll be reserving.
Okay. Mr. Burnett?
Yes, Your Honor.
You'll be giving this morning?
Yes.
Ms. Nunzio, I would begin with you. I'm not holding you to a time limit. My thought would be to release everybody for lunch and have the openings for you and Mr. Barnett after lunch. I don't want you to feel constrained, and I want everybody to pay as much attention as possible. So, is there any objection to that?
No, I agree, and I thank you, Your Honor. I don't want the jury thinking like, we're gonna get to lunch or I'm hungry, so I really appreciate that consideration.
Okay, Mr. Barnett, any issue with that? For you?
None.
So what we'll do is give them about 5 or 10 minutes to get their selection for lunch down. My thought would be to have everybody come back ready to go at 1 o'clock. As soon as you all have prepared openings, so you shouldn't need a long for lunch today. And so we'll take a quick break. I would like to see the attorneys in chamber.
No tricking. All rise, please. Court is now in session.
Thank you. All right, the record can reflect that we're back from lunch. The jury is still outside the courtroom. Where we left off is we'll begin with closing, or actually, opening on the defense side. When the jurors come back in, anything that we need to talk about before we bring them back to Mr. Ralston?
We dispersed some exhibit books to everybody in the court. That's really the only update.
Okay. Mr. Nunzio, anything for you?
I'm going to stand up and verbalize my nothing further, Judge, instead of shaking my head.
Judge, I haven't had a chance to go through these exhibit books. I don't know if they're consistent with the jump drive that we received, but I have no comments.
Okay, I assume that they would be, is that correct, Mr. Ralston?
Actually, it's not a jump drive, it's on the OneDrive. And, and we have the ability to look and see who's accessed it. And I'm not sure everybody's accessed what we put up on the OneDrive. Be that as it may, these are the exhibit books.
Okay, and when you say OneDrive, you mean the exhibits that were shared as reported by the court by officer?
Yes.
Okay. Mr. Barnett, anything to do before we bring the jury?
No, Your Honor.
Okay, all rise for the jury. Everyone procedures, thank you. Welcome back to the show. If you recall, the prosecution just gave their opening statements, now we turn to the defendants, and the issue with the defense side in terms of giving an opening. They can choose to do so now, or they can reserve the right to give their opening statement until after the prosecution has presented their case. I'll begin with you, Mr. Nunzio. Are you or someone from your team going to be giving an opening statement?
Co-counsel Christina Nunzio will be giving opening statements. Thank you.
Okay, thank you. Ma'am, go ahead.
Thank you, Your Honor. So I just wanted to thank all of you on behalf of all the defense. 3 weeks is a long time, and honestly, you guys have the hardest job. You have to go against human instinct. You have to listen to 3 weeks of testimony and keep it up here in your brain, but you can't start thinking about what you believe, what you don't believe, what's true, what's not true, and you can't talk to each other about it. So we do really appreciate the sacrifice that takes, that mental load you have to really consider going against what you would normally do. So we appreciate that. Our criminal justice system is one of the best in the world, and here's why. Mr. Olson came up here and he talked for about an hour. He showed you some potential exhibits, and Bill Knoll is still innocent right now. And you can't even consider what Mr. Olson said because it's not evidence. You get to determine what that is at the end of the case. Now, they have their version of what happened, and obviously defense has a different version of what happened, but you get to decide what actually happened. But in order to do that, you have to figure out what the elements are, okay? We've talked a lot about the elements. The judge is going to instruct you, and you essentially have to figure out two things: the action that the defendant did, and then what their mental state was when they did that, okay? So the definition the charge requires that the defendant provided material support. And the legislature, they defined what material support is for you guys. So kind of like back in math class when you have to have like x plus 2 equals a number, they give you x. You get to plug in what x is. So for example, the prosecution has to prove beyond a reasonable doubt that William Knoll provided training. Not that he participated in training, but that he provided training, okay? You can go down the entire list like that to help you figure out essentially what action is a criminal action in this case. And then you have that mental requirement. Did they know what was going on, and did they intend for those actions to help, the plan, the preparation, the facilitation of Adam Fox and Barry Croft's plan? Essentially, we're looking for the light bulb moment. When did they have that light bulb moment where they knew what was going on? Okay, so you have to have that light bulb moment plus a criminal action. Okay, it's going to be a lot of information, but that's what you have to decide at the end of the case. You're going to see a lot of timeline stuff in this case because it happened over the course of time, according to the prosecution, and there's no world context in that timeline. This is during COVID. I mean, at the beginning of COVID, no one knew what was going to happen, right? I mean, we have people going out and taking all the toilet paper because they don't know when the next shipment's going to go in. They don't know if there's going to be, the grocery store open, okay? And so while we're dealing with COVID and people protesting the masks and being really upset about, how our government decided to deal with COVID, we had George Floyd die. So now we have police protests. I mean, cities are burning. People are scared. People are scared during this time period. And it's fair to keep that in your mind when you review all of the evidence that happens in this case. Now, Bill Knoll has a healthy mistrust of the government, and that alone is not a crime. And he's a firm believer in his Second Amendment rights, not only to bear arms, but for a well-regulated militia, okay? Being part of a well-regulated militia is not a crime. You've heard a little bit about militias, okay? We have, Bill Knoll was a part of the Michigan Liberty Militia. That by itself is not a crime. You had the Wolverine Watchman Militia, and that being a part of a militia, again, not a crime. And then you had Adam Fox's group and Barry Croft's group. Now, I'm not saying that some of the actors in these militia weren't doing criminal things, but again, just remember, being a part of militia by itself is not a crime. Now, on that timeline, you're going to hear some events about Peebles, Ohio, and Dublin, Ohio, where these groups get together. And you're going to learn that the Knoll brothers believed and were fearful that maybe the government was going to shut down, that people were moving to defund the police. And they wanted to network with other militias. So they'd go to these essentially militia networking events that they thought in order to learn about other people and kind of get contact information. And a lot of things were said during those meetings, but if you're familiar with the phrase, words are wind, they mean nothing, right? They don't necessarily mean a crime by themselves. And you're not going to hear any testimony that Bill Knoll specifically knew what this plan was. You're not going to hear that light bulb moment, what was happening during those meetings. Now, some people were talking about inciting violence, and that to incite violence is a crime, but that's not why we're here today. In order to be a well-regulated militia, you have to train, right? So these militia members would go to what's called field exercise trainings, or FTXs for short, okay? During these FTXs, you would kind of, learn some first aid, figure out how to manipulate your gun, so take it apart, put it back together. Sometimes they do some 3-gun shooting exercises. They would figure out how to clear a building, okay? But these are just standard things, and you're gonna learn that the individuals that attended these militia FTX trainings, not all of them were charged with crimes. I mean, you have regular people going there just to learn how to do these basic things. And then you're going to hear about Luther. That was another FTX training. Again, in order to be a well-regulated militia, you got to practice how to be a militia. So that's what they did when they went there. And then you're going to hear about this surveillance recon situation. To give you a little bit of background on it, there are a couple of different ways that the federal government and the Michigan State Police had their ins to figure out what was going on, okay? You had 2 undercover FBI agents, Undercover Mark and Undercover Red, and then you also had a confidential human source, okay? That's what we call an informant, right? And his name's Dan, okay? So he was paid to continue to be a part of what was going on in order to tell the government what he was learning. You're also going to find out that these individuals had recording devices on them, and they wanted to record everything that happened. So not only did they have one device on them, but they had a second device just in case the first one went out. So almost everything that's going on is being recorded. There should be audio clips of everything. The prosecution talks about essentially what they believed the Knoll brothers' mission was on that surveillance trip, right? To see, where the cops were and kind of look out in the general area. You're gonna not hear any audio clips of the Knoll brothers being told, look out for police. You're not gonna hear any audio clips of the Knoll brothers pointing out police officers on the road. You're not going to hear any audio clips of the Knoll brothers pointing anything out during this alleged surveillance recon mission, okay? So keep in mind and listen for that. During those FTX trainings, you're not going to hear that the Knoll brothers put on any of the trainings. You're not going to hear that they led the first aid training. You're not going to hear that they set up the room clearing exercises or that they were teaching anyone how to do the room clearing exercises. You're not going to hear that they put on the training about gun manipulation. You're not going to hear them putting on anything regarding, how to shoot a gun, okay? So listen for that as well. After the surveillance, they come back the next day and they're at Luther, and that's kind of the light bulb moment. You're going to hear that's the light bulb moment for the Knoll brothers when they go, oh, Adam Fox and Barry Croft, they're serious about what's going on. At the end of this case, the judge is going to give you a bunch of jury instructions, okay? And obviously, you're going to get the elements of the crime for providing material support. We're also going to have the jury instruction for what reasonable doubt is. Reasonable doubt comes from the evidence and lack of evidence, right? So you get to take your common sense and you get to review what has been presented in evidence, and you also get to think about what wasn't presented, what you didn't hear, okay? And when you review that, you also get to hear about, the judge is going to instruct you about determining credibility. The evidence is yours, the testimony is yours. You get to determine whether or not you want to believe a witness. If you think a witness lies, you don't have to consider any of their testimony. If you think that, an exhibit doesn't match up the testimony that you heard, you don't have to consider it. You alone get to determine what evidence is relevant, what evidence matches up to a case. And if you don't think it matches up to anything, it's a distraction. It's a distraction from the real reason we're here and what you need to determine. At the end of this case, you then get to weigh the credibility, look at the evidence, and figure out whether or not the prosecution met their burden. If they proved beyond a reasonable doubt that William Knoll provided material support. And we believe that you'll find that they did not meet their burden, and we will ask you to acquit the Knoll brothers of this offense. Thank you.
Mr. Saber, will you be giving an opening on behalf of Michael Knoll?
No, Judge, we would reserve it to our case in chief.
Mr. Barnett, let me go to you. Will you be giving an opening?
Good afternoon. In 2019, Eric Molitor is living in Cadillac, Michigan. He's living in that area with his mother and his 2 children. Eric was divorced. He had custody of his kids. He's raising them. His ex-wife lived in Grand Rapids, Rachel. Eric was a parent spending a lot of time with his children. His mother retired from the Department of Health and Human Services right around there. Eric's family was a longtime family of guns and gun enthusiasts. They believed in the Second Amendment. Eric believed and trusted good government. During 2019, Eric questioned the direction our state government was going with firearms, firearm regulations. Eric, with his mother's support, presented a positive pro-Second Amendment resolution in front of the Wexford County Commissioners. It passed 9-0. Eric was engaged in government legally. He was speaking out legally. This happened all over the state. There were probably 50 counties that had that happen. But he was heard, listened to. His political message was heard by elected officials. And it meant something to him. It meant something to the process. Eric's grandfather ran a gun shop in Cadillac for many years in the 60s. And the heritage and tradition of weapons and firearms and hunting, those principles of the Second Amendment all came through his family. They came to him legally, honestly. They believed in the Second Amendment, Constitution, and they've done that for decades and throughout all of Eric's life. Eric enjoyed having a proficiency in firearms. He loved training with other like-minded people. He enjoyed practicing for competitions around the state to show off his proficiency and his firearm skills that his family brought to him. Eric was not in a typical militia recently. He was not a member of the Wolverine Watchmen that's been up on the screen, or the Michigan Liberty Militia, or the Michigan Liberty Patriot 3%ers, or any of the authentic Michigan militia groups that you may hear about in this case. In June of 2020, Eric joined an online Facebook page known as the Michigan Regiment of the 2nd Continental Army. It was not an actual militia, it's a Facebook page, never materialized beyond that. He actually joined a second Facebook page like that, a paramilitary group, not a real militia group. Just a paper group, not active, not authentic, not training, just a community of like-minded people. Years before that, Eric was in a militia, actual militia groups for a brief time. He didn't like it, he soured on it, and he didn't want to join again. He was known as Barricade. He's got some size to him, so his nickname, not his handle, but his nickname was Barricade. So he's carried that with him. You should know, and Christina just said this, that militias are legal. They're constitutionally legal, and being part of one is not illegal whatsoever. Militias are protected activities of association in the Constitution and are a part of our Constitution. Prior to any involvement with anyone in this case, of which Eric had an insignificant part, Eric had started his own civil defense group in Cadillac, the Michigan Defense Force, not a typical militia, a positive, self-entitled civil citizen defense force. He and some other like-minded people did not like what they were seeing in 2020. Riots, they're happening in Michigan. Antifa groups, Black Lives Matter, protesters invading cities, mostly Antifa in Michigan, Grand Rapids, Muskegon, Owasso, Detroit. You will hear that Eric and others went to cities. Eric went to Muskegon and stood guard. He went to protect businesses, to protect people's property, protect the streets from looters, rioters, and protesters. There were unruly groups that were literally taking over cities in all parts of the country. Law enforcement needed, fellow citizens needed it, and a defense force of citizens looked like a good idea to Eric. Eric was and is pro-law enforcement. He was and is pro-government. If it's being run right, not overreaching and making unconstitutional laws, infringing on citizens' rights that are protected under the Constitution, the United States Constitution. Eric believed and believes in a free America, not an America that deprives citizens of these rights and freedoms that we're all entitled to. In 2020, he was 36 years old, trying to start his own security business at the time. His independent networking was of other paramilitary training people. He was entering competitions. He thought that experience would help him in the security business. He wanted to get ahead, get his business off the ground. He wanted to be well-rounded, experienced, and knowledgeable in the security field. Eric focused on self-defense only and was not an aggressor in any way. He took an EMS class, but he didn't pass it. He didn't pass the test. He had some medical knowledge, but not enough to hold any certification. He had an interest in helping injured people. He had a good heart. You'll see that he's a kind person. In the spring and summer of 2020, COVID lockdown. Rules were coming from our state. They were rampant. Many citizens in our state were fed up and angry with the state's overreach. Many citizens held rallies and protested in cities. As I've mentioned, these groups were coming in, they were protesting. They had some inequalities, and we had some instability in our country. The state had clamped down on everything. Meanwhile, threats of these groups were coming in to our northern Michigan towns. It was a threat that was real to people. Militia groups were meeting with law enforcement to coordinate the defense to these rumored attacks. The government knew this. A lot of people were on the lookout for groups that they were uncomfortable with. And that was happening in Cadillac, where Eric lived. In fact, on a Saturday afternoon, we had militia up and down our city protecting property during a rally that happened in our town. Eric was not there. He was working that day. Cadillac's just up the road from Grand Rapids. And if you didn't know it, they had rioting, burning, looting. Some arrests were made, not in all. It seemed in areas like Grand Rapids, the rioters, lawlessness was not held in check or properly managed by law enforcement. Law enforcement was outnumbered. This was the background and atmosphere of 2020. This is what Eric knew about. To me, the summer had a lot of touchstones. When I was 9 years old, there were riots in Detroit. There was a lot of unrest in our country. And we saw cities like Seattle just taken over in the middle. Police couldn't control it. I think people were getting worried in the country. And people like Eric were right to try to step forward and help law enforcement. It looked like our government could fold in front of our eyes. Some probably felt they needed to arm themselves to defend themselves. It was really a time of uncertainty. So Eric took steps himself. He attended training opportunities, rallies, protests, gathering, all in peaceful stances and for defensive purposes. To be there for law enforcement, for protesters, for property owners, business owners. Eric was there. Again, he went to Muskegon at one point and stood guard and helped the police. Eric first saw a person by the name of Adam Fox at an online training. I believe it was for medical. I think the Zoom screen. That's where he had his first contact. It was in 2020 with this gentleman. He later met Adam in person at a Rosa Parks Circle rally. His picture was here. He's standing guard. He sees Adam Fox, crosses the street, shakes his hand, says, "Hey, nice to meet you. I saw your face before." The two of them exchanged names, basically. They had some online exchanges after that. And Eric was convinced Adam wanted to do things politically right, that he was doing things the legal way. This is how this started off. Eric agreed online to join his 2nd Continental Army militia Facebook page. That was in the late spring, early summer, 2020. He jumped right in. I think you heard the tape. I'm not sure that was the answer to what was said by Mr. Fox, but he did like Mr. Fox's message. It was legal and constitutional. He added himself to another page just like that. So he's on 2 Facebook pages, just chatting with people, nothing illegal, reading and discussing paramilitary stuff online, looking out for trainings for firearm proficiency. But Eric liked and agreed with Adam's message and beliefs that he found on Adam's page. They were all legal and constitutional. They were in line with the times. And no actual militia group materialized from this Facebook page or the other one he joined. Eric was not in a militia in 2012. He was focusing on citizen defense, protecting others. His team grew, and a retired Wexford County deputy took it over. Eric had additional online discussions in 2020, in late spring, early summer, about the lack of freedoms, how government was out of control with overreach, and that he was frustrated with government. Frankly, many citizens of Michigan were. Many citizens were hurt by lockdowns, the closings of small businesses, livelihoods taken away. It was a crazy, tough, uncertain time for everyone. What's next? The FBI knew nothing about Eric. He was not a threat or a suspect to them. But unknown to Eric, the FBI had been watching and infiltrating a downstate militia. Some of these guys were so poorly trained, they were crawling in the ground with their rifles. They were going to kill themselves. They're just terrible. Until the FBI sent in an informant, supposed to be a listening post. He becomes second in command. He's training these guys. His name's Dan. Train them to be dangerous. I'm going to jump around a little bit. Mr. Ralston did too, and I know why, because this is complicated stuff, and the timeline is not easy just to lay out. But August 29th is an important date because Eric took a ride that day. I want you to know the reasons why. But he knew none of what Adam involved himself in that summer. When Eric got in that truck driven by a government informant and carrying a passenger, he had no idea Adam Fox was an FBI target and a patsy. He didn't really know anything about Adam or Adam's contacts. He had some brief contacts with him. He talks to him on his Facebook page. Saw him at that Zoom training way back 2 months before. He respected and looked up to Adam. Adam wasn't showing bad things at that time. Adam was being used and manipulated by the FBI, and neither Eric or Adam knew that. Eric didn't know the FBI was plying Adam, manipulating him, instigating, supporting, manufacturing some pretty serious criminal thinking. It may or may not have happened without their support. Adam Fox helped Eric, though, find employment in his life. Adam happened to work as a security guard. Adam had connections in the security field. Eric got good pay. He became confident in his security skills. It improved his career outlook in the field of security. So Eric was grateful, appreciative, thankful. He had a break finally. This gentleman from Grand Rapids, Adam, was helping him with employment opportunities. Eric worked for a U.S. Marshal, Sam Riley. That's Adam's guy. That's Adam's employer, a U.S. Marshal. This guy ran a multi-state security business. Adam got Eric excellent jobs working for Sam. This is what Eric needed in his life right then. And he was thankful. He kept in touch with Adam because he had these jobs available. Eric even traveled out of state and worked security under Sam Riley for a TV station, Telemundo. He guarded some television personalities in the field. That's all thanks to Adam. Eric worked at Menards, worked in different Michigan cities. He got a security job. He sat out front. People didn't want to wear masks. We needed security all over the state at that time. So he put himself in harm's way, took this work, took it from Adam, and was thankful for it. He had to stand in front of Menards and make sure people wore their masks. Adam also liked to lift weights. He's a bodybuilder. He was in good shape. He talked to Eric about taking steroids, and that was attractive to Eric. He has got some big size, a desire to lose weight and to be in shape. This is what Eric did wrong here. He had goals of having the security business, paramilitary training, but he wanted to have better physical shape. And he saw Adam as a possible way to do that. He never got steroids from him. It was a thought that he had a goal. He had a goal to not be heavy, to be a better security guard. Eric collected security tools. He's going to take this stand and tell you about them all. We're going to go through all of the exhibits that have everything to do with Eric. He's embracing it. We're asking that the exhibits come in. He's going to explain each and every one to you. He wasn't questioned before he was arrested. His side was never considered. They're going to call it a takedown. They brought, 30, 40 police to his house, had a loudspeaker outside. Come on outside. They did this to everybody all at once. They call it a takedown. This was an arrest. He had an arrest warrant. They came out to get him. Could have had one officer come out. They didn't talk to him before they arrested him or charged him. They took their side, just like you saw their side to start this thing off. I want you to keep a really open mind as a juror and as a team here. You are the judge, basically. You're wearing the invisible black robes. You're going to find the facts. You're going to presume innocence, find him guilty beyond reasonable doubt or not. Not guilty. If they don't make their burden. They have their burden. We have no burden. We could sit over there. I could look up at the ceiling, look at my cell phone, sit there all day long, do nothing. We're not going to do that. We're going to talk to you. I'm going to let Eric talk to you. So Eric collected security tools. He liked to show them off. They're legitimate. They're legal. He wanted to have his own business. These tools would impress his clients. He's got legitimate reasons for them. What Eric didn't know, that there was a person named Dan. Dan had gotten close to Adam, and Dan was a paid informant for the FBI. He was an informant who got paid. Got paid $54,000. Some of that was for a house he moved. Others were for its expenses. This was a guy who was supposed to be a listening post, just show up and listen, report back to the FBI. Eyes and ears. We heard that this morning. Dan was the eyes and ears of the FBI. The more time Dan spent, the more people pulled into Dan's circle. It seemed the more he got paid. Got $54,000 at one point, $4,000 laptop. I think he got some other personal items at that as well. He's going to come and testify here. We're going to meet Dan. He's supposed to be a listening post. That changed quite a bit. At one point, Dan encouraged the other militia members to fire a firearm through the governor's cottage when she wasn't there to send a message. He gave out an idea to send rifle shells, bullet shells, whatever they are. I'm not a weapon guy. They're going to send shells. He said, let's send shells to her house. That'll send a message. He's telling the militia people group, do these things. But these are his ideas. This is the listening post. It's supposed to just listen, report. Second in command within about 2 months, whatever it was, he shot right up in this group. He trained them. He gave out those ideas. Those are like the ideas they're accusing the other side of doing. Eric never did anything that bad. Dan was well outside his defined role. They gave him admonishments. He violated his agreement with the FBI. They didn't care. Kept going. Never mind about the listening post. Dan's making good money and the train's being led by Dan. He's got the encouragement of Henry Impala, one of the agents, and Jason Chambers. Two agents, two partners. I believe they're both from Genesee County area. They both have a vested interest in this case. It's their jobs. They're the current FBI. This is our FBI today. By August 29th, Eric still knew nothing about Dan or any of these other people downstate in the militia group, the Wolverine Watchmen. Dan trained them to become dangerous. He was just not the listening post, second in command, leading their training sessions. Eric never heard of the Wolverine Watchmen until Dan came along. Eric saw the Null brothers. He saw them at rallies, standing on stage with law enforcement. He knew them to be pro-law enforcement as well. He trained a few times with them, but at training sites with a lot of people. These were popular. These FTXs, it's military lingo to me, but it's field training exercises. These guys love it. So they have a common hobby. Eric saw the Nulls at a few. I think the Nulls probably saw Eric, so he knew of them. They probably knew of Eric, but that's it. There's no crossover. None. On August 29th in 2020, and just before that was when it was getting pretty hot in northern Michigan about outside groups. And they could have been more than Antifa, could have been more than Black Lives Matter. There's groups of citizens taking advantage of this unrest. And threats are coming across to communities, and people like Eric were looking out for them. On the 28th, and before that, Eric was out looking at hotels and motels for vans of people. And there was a credible tip that came up that vans were coming up to Cadillac and or northern Michigan and Traverse City. And he's driving around looking at hotels and motels. You'll see some writing on this. This is all going to be proven by the state's case. They're going to show you exhibits. Hey, let's go scope out some hotels and motels. I'm going down to Big Rapids. I'll check out a few there. I'm dropping off my child to Grand Rapids for his ex-wife's visitation, parenting time with his 2 children. So Eric is on the lookout, scoping out hotels and motels, working in conjunction with his team, with law enforcement, defense groups, his defense group to protect others. The retired deputy that took over his group was a mediator with law enforcement. His name was Duffy Luter. Worked in Wexford County, retired. On August 28th, one day before the ride, Eric was told by Adam Fox that Adam was going to take a ride to look at a high-level vacation home in northern Michigan. That's all Eric knew. He didn't know Dan was the driver. He didn't know Dan at the time. Eric assumed these two groups were gathering up north and needed to be watched. Eric had no idea that Adam was referring to the governor's Elk Rapids cottage, or he would never have gone. He was told the vacation home was in Bel Air. Eric didn't figure it out till last week. Bel Air is not Elk Rapids. He's not from here. This ride was put together by Dan, Agent Chambers. They tried to get several people to come. Ty Garvin, you'll hear this name. Michael Moray, Daniel Harris, Brandon Caserta, Caleb Franks, Sean Fix were all invited. Come on, and they knew what's going on and didn't come. So none of them can go. Instead, Dan drove only Adam to Cadillac and picked up their only unsuspecting person, Eric Molitor, at his mom's house. Right on the way, these people met Eric's mom. They seemed well-meaning. Eric used marijuana, and he drank some moonshine that day. He's a marijuana user. He and Adam smoked marijuana at Eric's home, and then smoked throughout the day at different spots. That is something they also had a joint connection, not to use a play on words. They had a connection, marijuana. So they smoked some of that. Dan declined their offers to smoke. They left. They went to an unknown vacation home that Eric didn't know about. When Eric was outside his home, before they got in Dan's truck, Eric pulls out his RF device. He's showing this off. This is what militia people do, security people do. They love their toys. This is a $50, $60 toy. You buy it in the back of a magazine. He's got it. He says, guys, look at this. You have to hold it up to a phone to make it make a noise. It's such a piece of junk. Eric knows how this thing works. It was bought for different reasons than actually working. But it's really important to know he brought this RF device out to show these two people before anybody got in the car and anybody said anything bad. He already said, hey, check this out. And Adam says, hey, Eric, bring that to our next training. Now, the next training was in Luther. It was already set up. It's helped to be set up by the FBI. They wanted all these people to come together. And Adam's like, hey, bring that. You need to bring that to our next training. Militia groups are interesting. They probably don't trust people. They don't trust government. There's this aura of distrust. And they're paranoid for whatever reason. It goes right with their thinking to a degree, that they're paranoid. So Eric's thinking, okay, I'll bring it. First of all, Eric was going to bring it anyway. He was going to show off his little device. Hey, look what I have. Walk up to his buddy with the cell phone and go, ooh, make a noise. He saw it online where a security guard was putting it around the car in front of a client. He thought, wow, that's great. I can impress my clients. And Eric's collecting these tools for security work. So before they get in the car, the RF device is talked about. Adam says, hey, bring that there. It's already committed. He's going to bring it. They can put as many texts as they want up on the screen. This thing was set up before Eric knew anything. He didn't know what Dan and Adam had in mind. Supposed to have the capabilities of detecting infrared light. It's like an IR device too. Eric tried that out. It didn't work. That's a nighttime thing. It didn't work. It's supposed to show if there's like, radar or whatever comes out there, infrared light that sets off, alarms. Didn't work. Piece of junk. He didn't want to tell people, but he was going to take his toy to the previously scheduled paramilitary training. Kind of training that Eric routinely and legally attended and enjoyed. So Eric gets into the truck. I'm going to tell you the whole story here, so bear with me. This is where it starts, August 29th. He gets in the truck, Adam's in there, I don't think Dan's in there yet. Here comes Adam. He starts saying, we're going to blow up her boat. He's got this voice. Too many steroids, too much marijuana, whatever. He's got a scratchy voice. He's going to blow up their boat, her boat. Eric's like, what is he talking about? And he says, we're going to the governor's cottage. Dan's getting in. Eric's thinking, oh my God. Is he joking? He's thinking he was joking. Dan played along. So did Eric at that point. Eric was hoping this was a joke. Dan's wearing a wire. This stuff, they had a 5-hour trip. And yeah, they're going to play you these little minutes like that. You know why? Because almost nothing was talked about. They'll probably have, 6 minutes out of 5 hours. I don't know. We'll find out. Doesn't represent the trip at all, what they talked about. I'm going to go through it with Dan when he comes. He's not testified in this case yet. I'm going to go through that ride. We'll figure out what they said. But Adam said some crazy stuff. I'll use that word. It was crazy. And so this is getting recorded. Adam's impression of a dark joke is how Eric took it. So Eric thought that was time to make his own dark joke. He says, I can see your voting privileges are revoked. That's the secret sign. He's just trying to nervously say something. This is all going to be shown to you in exhibits, and Eric's going to explain this all. It's going to be right there. There's no covering. You can see his body language, everything. Here he is making a dark joke, thinking this can't be real. So they start driving up there. Eric felt misled because he's on a ride he didn't want to be on, but they didn't talk about it much going up to what he thought was Bel Air. He was told he was going to Bel Air to look at a high-profile vacation home. That'd be Airbnb, whatever they're called, these rentals. I don't know. Would he know? He wasn't told. He certainly didn't know it was the governor's cottage. So this was Dan's truck, Dan's gas, Dan's idea with the FBI's assistant. They're going to go up and scope this out. The 5 or 6 people they wanted to have come dropped out, and they're stuck with Eric. They need numbers, folks. This is a big thing. They want numbers. They needed to justify the investigation, the cost of it, the time that these people put in. I think one of the agents sent 3,000 texts to one of the informants. Just the evidence, the paperwork that they just put together would probably come up to my waist or higher if it were printed out. And the FBI is heavily in this because they've got Dan. They're telling Dan what to do. And he's enhancing everybody's involvement with his training, with his suggestions, and with Adam, who's a patsy. In other words, he's just being used by the FBI and also thinking of some criminal things. But they did all this by putting Adam on the hook. So these 2 guys are high on marijuana going up there on this ride. Eric's thinking, who is this guy driving? These guys have guns. He's stoic. He seemed professional. Eric was caught off guard. He didn't even know Adam very well. They're going to say Adam and Eric are close friends. I want you to watch his testimony when he talks about his relationship with Adam. Not a close friend. If they cared to talk to him before arresting him, they would have known that. Eric was paid a lot of money for providing security, and that connection paid off financially, and it did handsomely. Didn't see this coming. Eric didn't know any of these people that Adam had secretly made connections with. Not Barry Croft, Eric rather doesn't know him. Eric doesn't know these people. Had Eric next to Barry Croft in a video that they stopped and freeze framed it. You guys are moving around with 29, 30 other people training at Luther. They catch a picture with Eric and Barry Croft. Oh boy. Then they crop it down and sat right up there on the screen. You got two guys there just walking by each other. Smear. This is what's happening here. It's a smear tactic. These exhibits. They're not fair. It's not a fair prosecution. It's not factual. Taking things out of context. So you see Barry Croft's picture up there. A crazy guy wears the sideways hat, spouts off just crazy malarkey. He's not Eric's friend. Eric doesn't know the guy. He trained with him with 29 other people and walked next to him. They get him in a video and they show us to it like it's a picture, like they're posing. And it does look like Barry said something to him. Doesn't know Daniel Harris. Doesn't know Brandon Caserta. These guys are Wolverine Watchmen, Ty Garvin, Caleb Franks, Sean Fix, Joe Morrison, Pete Musical, Paul Beller. Oh, look at these names. These are names you probably recognize. This has been going on for 3 years. It'll be about 2 years to figure this out. The last 3, though, were from the Jackson area. And the leader, XO, second in charge, is Dan training these guys. He's the Wolverine Watchman. We've heard all about the Wolverine Watchman. That's Dan. He built them. And again, Eric knows none of these people. None. He knows Adam. He unfortunately met Adam. He sparked up this friendship because he got things from him. Jobs, possible steroids, training opportunities. That's it. You're going to hear about chat groups. They're so encrypted. Well, sometimes when they're encrypted, messages delete. They're self-deleting. My son had Snapchat. He thought that was pretty cool. And I would go back and try to figure out what he is Snapchatting to people. He couldn't find it. It's kind of common, actually. There's private Facebook pages. They said they got them all from search warrants. That's really not true. Because the chats they were taking pictures of them. So Dan would turn over his phone to the FBI, or they'd give him access to get in there and just watch what people are saying. And these guys are all tough talk. Nothing happened. Nothing was going to happen in this case. But you're going to hear about these chats, and Eric knew nothing about unlawful chats when he got into Dan's truck to go to Bel Air. He's totally in the dark. He's a loner, kind of kept to himself, peaceful, nonviolent, and a compassionate person, cared for his children and his mother. He talked about meetings. Eric didn't go to any meetings. Not one meeting. They're going to tell you about meetings. He skipped over it. They gave you the Reader's Digest version, even though it went an hour, 20 minutes, whatever. Mine should go about 70, so hang in there with me. Eric didn't go to one meeting. They're listing several of them. There's a Munich training meeting in June. No Eric. He was invited, knowledge, none. No attendance. There was a second one actually in August too. Didn't go to that one. There's a list of these meetings are going to come out if they present their case. If they don't, I'll be asking Henrik to help us with the dates. There's an important conference call with the Watchman, Adam Fox, informant Dan, Harris, Garvin, Musical, Morrison, and a female, Amanda Keller. She is Adam's girlfriend. She's one of the group. So on this phone call in June of 2020, no Eric Molitor. Eric's sitting next to me, by the way, if you haven't noticed. June 18th, they had a Capitol protest, some of these guys. April 30th, there's no Eric. It's not anything to do with these guys. We had a basement meeting in the back shack. This guy, Adam, lived in the basement of a vacuum cleaner store that repaired vacuums. He had no bathroom. He had to go to the restaurant next door. I don't think he had a car. His wife divorced him. Guy was broke. I don't think he really worked. If he did, it was the security work. Didn't have much money. In the end of the whole operation, he had like, I don't know, $800 to his name, 600 at his house, and 269 or something in his pocket. When they presented his arrest warrant, they'll call that again a takedown. You're going to hear a lot of jargon, recon, takedown. It's an arrest. This is not Miami Vice. It was a July 7th meeting. Garvin, Franks, Harris, it's at Paul Bellar's house. These guys are on the other side of the state. These watchmen. Had nothing to do with Eric. Adam started training with them, though. They didn't even like Adam. He was loud, poorly trained, he was obnoxious. These guys didn't like Adam Fox. They had a Bellevue meeting, Bellevue, Michigan, Fowlerville training. None of these things with Eric. A Lansing rally, I mentioned that, April 30th. That's when they're outside the Capitol. Eric, were you there? He doesn't remember if he was even there at that one. He'll tell you. I'm thinking, hey, you would remember that because people went in the Capitol and were screaming. I think that was a COVID rally. They do a lot of these COVID rallies and they have a Second Amendment flavor to them too, obviously. So Adam Fox becomes appointed as a leader of the first chapter of this budding militia group that he's starting. It's called the Michigan Patriot 3%ers. And Eric was formally invited. Eric got invited to this new militia on the ride up. After he heard this crazy talk, we're going to go blow up her boat. Hey, Eric, I need to swear you in, says Adam. I've got an oath that just sent to me by Sean Fix. You need to be sworn in. I would need you in my militia. Eric, I want you to be an officer. I don't know if it was lieutenant or sergeant. I think it was lieutenant. Lieutenant Eric Molitor. You know what he told them? The police report said he accepted it. They didn't. There's mistakes made in this case. That was just one. He told him no. He had heard enough when this trip started. He turned down, Adam Fox turned down his militia invitation and turned him down flat. At that time, Eric felt safe to tell him, no. There's no enthusiasm this time. There was back in June. Let's get in those Facebook pages. He liked this guy's mantra. He liked the things he was saying. This guy has tweaked by now and went off the deep end. So there's a stark contrast between, hey, I'll at least be on your Facebook page to, no, I don't want to have anything to do with you. No way. So meanwhile, the FBI, they pulled in a pretty bad person. I'll call him Steve. He's from Wisconsin. He's a felon. He's going to be an informant for them. Wear a wire. Guy has a criminal record spanning 9 states, several decades. He was their go-to FBI, I'll call it snitch. It's not nice. He's an informant in the past and was brought on to snitch again. He's really dirty and untrustworthy. Eric had nothing to do with this Steve. This is who they bring in. Eric did go to one training at Luther. He was there out of the 29. They had wires, microphones, cameras all through this place. They had a family event. They had kids there. And people videotaping. They sign in when they go to these things. They put their names on there. They had a list of 29, 30 people that were there. It's not a secret training. It's a family get-together. It's what they do. And who's there? Steve. This is the type of individual the FBI is willing to work with. Agent Impala, at one point in this case, had to go to Wisconsin. And I won't say take down, but he intervened and went to Steve and says, Steve, we're worried you're going to kill an FBI source. This is Steve, the guy they're working with. And before that, the FBI themselves gave Steve a firearm to drive out to Delaware to give to Barry Croft. He wears a little pirate hat and a black beard. He's probably about this tall and he's kind of scrawny. But they sent Steve with the firearm through several states, armed, to felony record to deliver it. To deliver it to Barry Croft to get things going. He's a felon in possession of a firearm. And I don't think Steve took the firearm, and they had to get a second informant trying to get it. Person that drove from Tennessee all the way to Delaware to bring Barry Croft all the way to this area. I think it was to Wisconsin, just to make sure he'd be there. And I think that gal took the gun and tried to get it to Croft, who was anti-government crazy. So Steve goes behind the back of the FBI. This is how bad he is. He went to be a double agent. He's working for both sides. He's tipping them off. Hey, you're going to get arrested. He's telling them what's going on. Totally untrustworthy. He made the FBI look foolish. They knew his criminal record: theft, bail jumping, fraud, assault. They hired him anyway. He either was hired or he did this to get something off his record. He had Agent Impala testify before, and he wasn't sure if he was paid or not. Henrik sure got in his car and drove to Wisconsin fast to try to figure out if he was going to kill a source, a confidential human source, I take it, had their life in harm's way. Because Steve brought in another guy who was by the name of Higgins, and Higgins ended up getting charged, and Steve wasn't happy about that. So he went rogue on them. He worked for 3 separate FBI offices. So he was arrested. Next thing that happened is not only did he become a double agent, he's arrested now. He's got a huge gun, a 50 caliber. I'm not sure what that is, but it's illegal. I think it's an illegal gun that people shouldn't have in the way it was set up, and that he had a felony record. He was arrested with that, charged, and convicted. Here's their informant, right in the middle of this case. You know what? He went on that second ride. His name didn't come up, and this is why I'm bringing it up to you, so you know a little background, just the facts. You deserve the facts. This guy was on the second ride, wearing a wire, on September 12th of 2020. Steve's in the car. Another gal, Jenny, I mentioned, from Tennessee. You may hear that person's southern accent. She had a telephone on her at the Luther event. They're going to call it a device. And somebody, I'm assuming it's Adam, they don't have video, hasn't come out yet, but somebody held the device that Eric gave next to her phone, and she got in trouble because she had a phone on her. And you need to put your phone back in the car, because for whatever reason, these guys don't like phones. They're paranoid. All 30 of the people there. This is just what militias do. I don't get it, but they love their privacy. She had to take her phone back to her car and then throws her phone in the car. She's all mad and comes back and continues on with the FTX. She's not outed as a informant. The RF device did nothing. Eric wasn't around. Eric didn't know the FTX had anything to do with the governor. I'll get back to the RF device, but that's what happened with Jenny. So these 2 informants, Jenny and Steve, started doing what they could to bring Barry Croft and Adam together. Let's get these guys together. These threads, I think they call them threads. They'll call them threads. Whatever. Wolverine's the 3rd thread. That's Dan. So they put Adam, Barry, they try to get them together. Adam actually had met Barry online, probably in 2019 or so, but it's just typical Facebook comments here and there. These guys ended up being together at a meeting that Eric didn't go to, but it was all set up by the by the FBI. You're going to have to look at Eric's testimony, his actions, his explanation of the exhibits, and figure out what his intent was. They're bringing up motive. He has no motive. He doesn't like the lockdowns. He's not going to do anything that crazy. He doesn't like doing anything bad to somebody. What's his intent? We have to look at intent. In that statute, for this charge, you're going to see the words knew, K-N-E-W. He knew something. He knew this. But the most important part is the bottom. What was his intent? Did Eric have an intent to cause things? I'll get that little short list for you in a second. But intent, I want you to look at. So there were some other there was a Wisconsin training meeting in June, on June 6th in Ohio. So 2 different states. On June 6th, yeah, Eric took some employment. He's working at Menards, working for security. Adam told him, I'm going out of state. Didn't tell him anything else. This is what Eric needed. It was a job. He's got child support. Now he's got children to take care of financially, still to this day. But Eric wasn't invited to any of these things. He didn't go to them. Got in a stupid truck going to Bel Air, Michigan to see this vacation home. Stuck in the back seat. These guys drove up here with no address. Had no address. They're going to go look at the governor's vacation home with no address. So Eric's still thinking, man, what are they talking about? And then they started talking about it again. He says, Alan says, Eric, start looking in your phone. See how they have Eric's phone records? Yeah, he played along because he started realizing these people are nuts. He played along with them, looked up Whitmer's cabin, Michigan, whatever. They have those records, but they don't bring in Adam Fox's records, Dan's records, phones. These guys had phones. Adam's up there looking for it. Dan may have been. So they're driving around for an hour, basically, under my clock. This thing was a 5-hour trip both ways. They went to the Oasis Red Bull Tavern. We'll get to that. That's part of the story that's not being told. So they're driving up. Adam says, hey, look up your phone. See if you can help us find it. Eric found nothing. He got a dead end. He's playing around with them. He plugged in a few things. He's hoping this has got to be the Mackinac Island home. We're miles away. That's what he stumbled into. Stumbled into it. Not the Elk Rapids home. He didn't even know Elk Rapids existed in conjunction with anybody's cottage. So after about being lost for an hour, and Eric does a quick search, he can't find it. They're lost. So I think Dan asked Eric to look it up on Reddit. I think he meant Redfin. I don't know. Eric doesn't find anything there either. So Dan engages him. Eric stumbles on Mackinac Island. That's where it left. So Adam calls a guy by the name of Sean Fix. And Fix, I believe, was a watchman. In fact, he was an officer in a militia. So he calls Fix. Oh, he's Adam's XO. XO means second in command. So it's confusing, but Fix is working under Fox. And Fix is in, I'll say, Genesee County area, approximately, maybe south a little bit. And Fix gives a vicinity. It's over by Birch Lake. It's by Lake Michigan. It's on this side of Birch Lake. So there's 5 hours of audio going on and on and on. You know, they're talking normal things. But at this point, you could hear Adam say, is she 49 years old? Which she probably was, our governor at that time. So Adam finds it. And I believe they were smart enough, not sure how they got there, but I think they put it in Dan's GPS. at that point. Dan was instructed to not, I don't think they gave him the address. He was gonna have a good act, didn't want to be put in harm's way. This was dangerous. I want you to think about the danger of two guys sitting in the front with guns that Eric doesn't know fully well, one for sure, the other one he kind of does. And they had a safety plan for Dan, they didn't have one for Eric. These guys had guns. And so Adam, the tapes don't let you hear because there's a lot of noise. They are junky tapes, actually. You're going to get a little portion of them. The tapes, I believe, will tell you that Adam found this place and then it went to the GPS. I don't know if it was Adam's device. Don't know that because that evidence is not being shown to you. They don't want you to see what Adam did in his phone, but they sure have Eric's phone up there where he did his search. And Adam's the one that found the place. So they get to the street that the governor lives on. It's her summer home, one of her cottages, not the Mackinac Island. It's in the vicinity of Birch Lake. I'll leave it at that, but there's a street, and they're going by that. And Adam says this, "That's it. That's it. That's it." He sees it. He recognizes it. How is this guy going to recognize this house? It was testified at an earlier hearing when he was looking up things on his phone and he was looking at photos. He had photos of the place. He said, "That's it." In fact, evidence that has not come in this case yet will show you that the Wolverine Watchman had the picture of her house, the same picture, May 22nd, 3 months earlier, on the Wolverine Watchman Facebook page with her address on it. It's publicly out there. It's on Zillow, Realtor.com, all these things. These guys had access to it, whether they were good, bad, or indifferent. They were probably harassing the governor at that point, but they had the picture already. 3 months before Eric Molitor took his video, which happened after Adam took a bunch of pictures. You saw the picture with the guy's face up there, the nice picture of beautiful blue cottage. That's her cottage. There's Dan's face. He's the driver. Adam's taking pictures both ways, coming down and back. He went down again. He went 4 times by her cottage. Eric's like, "Come on, we've seen enough. Let's go." So video pictures is what was taken by Adam. They're 2 seconds long. If you got a fancy phone, it takes live pictures. They're just not quick photos. They go for 2 seconds. You can see it's going from here to there. So those pictures were taken by Adam, and a nice picture with Dan. They had a perfect picture of the place. They have it already from the Wolverine Watchman page with an address. Adam takes this picture. Off they go to the Bull Tavern. Oasis Bull Tavern, Red Bull Tavern, sorry. You guys probably know that. Eric's petrified. He gets there, he sits in there. Adam starts looking through more real estate sites. Zillow is what we've been told. He's looking at pictures, either house plans or blueprints, cottage online. Dan gives paper and pencil to Adam. Draw a map, Adam. Here's your Pepsi. Draw a map. So Adam starts drawing a map of the cottage, the lake, and there's the FBI right across the boat taking a picture of them. Now let's provide the paper and pen. They didn't tell you, won't tell you that. These pictures, by the way, are still online today. I'm not sure why this happens in this world, but all of our homes property are up there. The one picture we'll have as an exhibit, I'm not going to be as high-tech as the prosecutor or the attorney general's office here. I'm going to hand out and let you look at my exhibits, most of them, or hear them. It's a picture, it's some paper with a printout from a realtor company. You can see all sides. Eric took a picture, a video, a slow motion video, we'll get to that, but on the street side. These guys were going to come in on the boat side anyway. these Realtor.com pictures, for example, and other ones, we presume, because we haven't been given any of those, or shown what he was looking at, but there are pictures all over the place on both sides of the same house. The house was brown in the pictures I have. Here, Adam says something about the paint color is different. So we have that exhibit. It makes sense that he found this on Realtor.com. We saw it somewhere because he says, that's it. This guy already knew what this looked like. Couldn't find it for the life of him. Didn't have an address. I mean, how dumb is this whole thing? Adam had a Google Earth app, by the way, as well on his phone that was confiscated. Some messages were taken off, but none of the great details about what he searched and what he found, either on the road when they're coming up there or in the Oasis Red Bull Tavern. That's interesting. I don't know if he was on Zillow, Google Earth app, Street, Realtor.com. So Eric sits in this tavern. I've been calling it a diner. It's during the day. All this is in bright daylight. They got at Eric's house at noon. This is probably 2:30. Beautiful sunny day. And they're sitting in there. And Adam, Dan, and Eric are going to order food. Dan's paying. Eric orders an olive burger and a pop. Eats it. Doesn't say a word. Doesn't say a word. Meanwhile, Dan, Adam going back and forth. Dan's telling Adam, quiet, shh, not so loud, don't talk so loud. Meanwhile, Eric's saying nothing. So he had nothing to do with anything that happened at the tavern. Whatever Adam was doing there, and we don't know, other than seeing him draw a map and taking pictures, getting pictures taken of him. Eric didn't do anything, got himself an olive burger. I'm not sure how he ate it because he was freaking out at the time. Prior to going in, Eric put his weapon in the back of a truck. He had a weapon on him. He had his firearm. The guy lives with his firearm. He sleeps with it sometimes. There are people like this. Eric is one. You'll see him in the grocery store. You'll see him at the bank. You'll see him in maybe not the bank, but other places. Maybe they catch your eye. You're wondering. These guys worry about self-protection. He just lived with his weapon. That's all he did. It's another day for him. He had a habit of it. It was routine for him. So he had it with him, and he thought, well, I'm not sure about the rules for a bar. It's technically a bar. Alcohol is sold. So he does what he thinks is the lawful thing, puts it back in the back area of Dan's truck. So there's no question he had a weapon. He's going to tell you the truth and explain all this when he does take the stand. So he goes in to order. He's literally trying to figure out if he's safe with these guys or not and what to do about this. This was a 5-hour round trip. Crazy things are said. They were talked about at first and not really until they got closer. The ride was arranged by the FBI. It was a flop for them because all they got's Eric. And here he is now in a tavern in Kuwaitan, I guess it is. Kuwaitan. Nice place, it looks like. Eating an olive burger, wondering what's next. So, they smoked some marijuana again, I think, out in the parking lot there before. It went on constantly, kind of all day. 2 people were high on marijuana. I don't think Eric's going to tell you that's an excuse for anything that happened or a reason, or that nothing would have happened had he not. I'm just telling you this is what happened. You might understand half of Adam's craziness in the things he said if you knew he was constantly high on marijuana that day. But Eric had his stuff together and was freaking out. So eventually they left the Oasis Red Bull Tavern, and Eric's hoping they're going home. They don't. They go by the place again. Adam's taking, I believe, more pictures or video. They come back, they go down, they come back. Eric's saying, this is nuts, let's get out of here. And Adams looks back, barricade, just what you heard here. You got that little snippet. Now you have a little bit more of the background. It's not like, hey, barricade, do this. This guy's panicking, freaking out in the back of the car. His so-called buddy, his acquaintance, hey, barricade, do me a favor, take the video, slow motion video. Yeah, what? He says in the back. He's not comfortable at all doing this. He puts it up on the window like he was asked. It shows the house before, and it shows the next house. Who cares? That's the same pictures they've had. They already took. This is a nothing video. Meaningless. Eventually, they left town, drove back. I'll get to that in a second. 2 weeks later, the other group came up with Adam, not Eric. Eric didn't give anybody a RF device at Walmart. That's BS. That never happened. Eric left his RF device. It was said this morning. I want to clarify. I can't criticize it. He didn't give anybody an RF device to go up on this ride. They're reaching, stretching, misrepresenting these facts. Eric left his RF device back at the FTX, put it on his table. The rest of his, I call junk, but his valuable collector's items that he trains with, that he goes into competitions with. So don't believe everything you hear, because there's some mistakes being made in this case, whether it's intentional or accidental. They're mistakes. 2 weeks later, this group came up. They can't find the place. This video was so helpful that they drove around and around and around in the rain, in the dark. Nothing. Couldn't find it. They had the wrong address. They can't even keep an address. How are these guys ever going to do something? How would anybody know they're going to actually do it? They couldn't find it. That was one car. You saw those pictures in the dark. How helpful were those? One of those guys had a camera on his. They're just driving around. You see out front. There's also a view of the three people in the car. You might see that as an exhibit. They didn't even have the right address. These guys were the bad news bears. They couldn't have pulled this off if they had to. They couldn't even keep the address to put it in a GPS. 2 weeks later. So they leave the tavern. They're thinking they're going back. I forgot something here, and it's very important. They went to a boat launch next. Boat launch, okay? They pull in. Eric stands by the truck, gets out, wants nothing to do with this. These other guys, two guys, Dan and Adam, walk 80 feet over. They go behind a bunch of bushes. Eric can't see what they're doing. Yeah, those two, not they, those two were scoping out this cottage. Not they. I've heard that today. They went to the boat launch to scope it out, to surveil it, to do recon, all these fancy words. Eric standing back by the truck like he wants nothing to do with this. Adam takes out his hat. This picture's something you're going to see. You're going to think he's got binoculars, but he's got his hat. He's, I think, looking through the top of his hat. These little baseball hats have that little hole. Apparently, if you look through that, you get a little more distance. I mean, this is the sophistication of Adam Fox trying to look at the governor's cottage from the boat launch. And where's Eric? He's 80 feet back, can't see what's going on. He's not having anything of this. He's not providing material support. He's hightailing it out of there the best way he can. Didn't say a word at the tavern. Didn't say a word down at the boat launch. He stayed there about a half an hour. They met a gal there. And Adam Fox, of course, started smoking marijuana with this woman. Giggle, whatever. That's actually what happened there. So they eventually came back to the car. They get in. They start driving home. Does this sound like a guy who has intent to create coercive in the government or cause harm to a citizen or to a community? The words are, and the question's going to be, because there's a jury During jury selection, you guys heard elements, and there were eggs and cakes and all that BS. Excuse me. Sorry. And elements were talked about. If the elements aren't there, they got nothing. Whether there's one element, 2, 3, however many eggs, they got to have them all. You're going to see at the bottom of this thing, this is the easy one to see. Did Eric have intent? Did he have intent to intimidate or coerce the civilian population? Did Eric have intent to influence or affect the conduct of government through intimidation or coercion or any governmental unit or person? He had no intent to do anything criminal. He just kept telling them to not go by the cottage. He kept telling them what they wanted to hear. He told them a few things to keep them off his back, and get himself home. All this guy wanted to do was get home safely. He's under extreme pressure there. They didn't outright threaten him. They didn't threaten him at all, but he felt very scared. Legitimate concern. It was real. The FBI, you heard how they painted through Mr. Ralston a dangerous picture and a dangerous persona of Adam Fox. And wouldn't that definition put a reasonable person in fear in this situation? You're going to find that Eric's not guilty of count 1. If he's not guilty of count 1, he's not going to be guilty of count 2 because there's no felony. You can't get to count 2. Coming back home, now Adam's coming at Eric one more time. Eric, are you in for the mission? And Eric's like, hey, I don't know what you're talking, I'm hearing bits and pieces. I don't know. He's thinking, I better say something. I got to go home. I can't tell him I'm not in. He doesn't agree. He doesn't say yes. He says he's in, but he puts conditions on it. Man, these conditions are never going to be met. I'm in if it's done professionally and no stupid shit. That's his way of saying no. And you're going to hear it from him and have him explain it to you. He said he's in, but, if. No stupid shit, professionally planned. Look what he just saw already. These people, or morons, whatever, they're driving around for an hour and Elk Rapids can't find it. This is not professional. They bring a hat for binoculars. They can't find an address on the internet. So nothing happened in the boat launch. They're driving back. This comes up. He gives them 2 conditions. 2 conditions he knew they could never make. There's also talk by Adam. He's going to put the governor in they're going to do this by boat. You come from the launch and go to her house. That's what they're trying to figure out where it was. And they're going to go on a boat. Whose boat? They're going to put her on trial and something about a court. It's all crazy, nonsensical stuff. This is all being said. It was ridiculous. Leaving her out on Lake Michigan was mentioned. I think it came out this morning. Whose second boat is going to do that? How is this going to happen? The whole thing was stupid. He wanted her inconvenienced. This is Adam Fox. You're going to hear that Eric said, I don't torture people. Well, they cut him off. He's going to say, I don't torture or kill people. And you got another exhibit that they're going to bring in that's only 50% of what Eric was thinking and trying to say before he got cut off on the tape. And he's going to tell you about that. So they're going to take her out on Lake Michigan without a motor, inconveniencing her. He's hearing all this crap and says, if it's done right, planned professionally, not stupid. So here comes a big part of this situation. You're driving home. Adam's continuing to say crazy things. Just nuts. Dan is looking back at Eric now. He's doing the eye roll. So what's the deal here? Is Adam serious or not? Even Dan wasn't buying into this stuff. The informant for the FBI, the trainer, the guy who said, hey guys, let's shoot a bullet through her cottage. It's like putting gasoline on a fire. Let's send shells to her house. This is the guy who's driving. He's very stoic this time, very professional. He's got this military background. He does in real life, actually. He was injured and deserves respect for that. And he came forward way back when because he heard someone wanted to hurt a policeman. These same people lied about fake C4, fake weapons, fake arsons. Everything was fake in that group. The guy did the right thing. Eric supports what this guy did. Doesn't probably like him because the way this went down and how everything's been twisted, but this guy was doing the right thing to come forward. This is way back. He ended up in front of Hank here, Henrik, sorry, Agent Impala. And they started this thing off. We started off down there, and here we are up here, and Eric Molitor in a car he didn't want to be in. He thought he was going out to look at DLM or Antifa and seeing who's coming into Cadillac to break in the windows of businesses. So even Dan now wasn't buying into this. Dan was playing along, so was Eric. Eric was quiet almost all the way home. Reached his home, went in, his mom's there, hi guys, they came in with him, used the bathroom. He showed off his gun collection, gave Adam a gift, he gave him a holster. Adam didn't have anything. Adam was not trained well. He wasn't a real militia guy, he was all talk, had no equipment. I don't know how he had any money when he was arrested. He had $260 in his pocket. He was supposed to take $4,000 down to buy a bomb, although the real truth was they were offered free gear. Everybody come down and get free gear so they can all arrest them at once. It's a setup. And then free beer, free wings. Sorry, even got better. Free gear, free wings. Almost rhymes. That's what they were told they were going to go. Yeah, some of the guys went down there. Eric said he would go down. That's October 7th. That's the end. So what happened? What happened in between August 29th? Eric gets home, shows off his gun collection, gives a holster to Adam. See you later. Adam, I believe, texted him the next day. Yeah, he said, hey, bring your RF device. Okay, it's just a routine training. Eric doesn't know the training's got something going on behind the scenes where maybe 5, 6 people were talking a little bit behind the other 25 people's back. Didn't know that. So he does bring it. Eventually on the 12th. Next day, Dan called him. Guess what? Eric didn't call him back. So the only thing he heard between that ride and the 12th and 13th, which was their standard training, was a couple texts from or whatever, chats from Adam Fox to say, hey, bring your RF device. Bring your RF device. Show it off. And Eric's thinking, great, I would show it off anyway. This is what they do. He brings it. Something else happened in between them two, though, because Dan and Adam were talking still on chats, and they said, Adam says this to Dan, hey, excuse my language. Hope my mother's not listening. 5 days later, Adam is writing to Dan in a chat, don't count on Eric for any extreme shit. He used his name Barricade. So wait a minute, 5 days after this ride, Barricade's not going to do any extreme shit. Adam knows that. He's telling Dan. Those conditions told everything. Is it conduct in the tavern? It's conduct at the boat launch. He's not in this thing. And his nickname from way back in his 2015 militia was Barricade. So 5 days after the trip, Adam is telling Dan, Eric's out. Can't be counted on. Eric was not in any plan, made no agreement, didn't agree to any plot. We hear a plot, plot, plot. Eric's not in any plot. He took a darn video that was duplicated and felt he had to get home to his kids. And on the way back, he starts seeing Dan rolling his eyes. 6 days later, which is 1 day after this, Dan still doesn't give up. He's asking Adam, would Eric be willing to drive? In fact, in the car, they asked him, would you drive? Would you be a medic? Eric's not a medic, by the way. He didn't pass his test. And the next day after this, don't count on barricade for any extreme shit, is a communication. They're still trying to get him pulled back in. They won't give up. Eric's on the fence, they say. Okay, there's no agreement. You're on the fence. Is that a contract? No. Could be if some condition precedents were met. They weren't. He gave them conditions he knew they wouldn't get. So Adam responds, we'll talk to him at the FTX. Guess what they never did? They never asked him at the FTX. Nothing of this came up at the FTX. Eric went through a routine FTX on February 12th. Didn't know anything was going on. I'm going to jump back for just a second because I want to talk about this photo. You won't believe this, but before these photos were all taken, there was some other discussion with Adam and a guy named Mark. He came to another Vac Shack meeting that my guy wasn't at. Mark is an FBI agent. So agents, the informants. And they're going to, hey, let's take pictures. Send someone up to take pictures of the governor's cottage in Mackinac Island. Beautiful pictures of gates with locks on it, walkways, how to get in, how to get out. What do you think they did with those pictures? They were so worried about Eric's video that he took. They took those pictures over and gave them to Adam Fox way before August 29th. He's got them in his phone. They gave him the same pictures they're freaking out over Eric taking. They gave Adam Fox, here's the pictures to the governor's cottage in Mackinac Island. The FBI. That's obviously not material support, or they wouldn't be doing a crime. They're not criminal. We're down to this one duplicate video in Antrim, because those other counties you're going to see don't matter because you need venue. Crime has to occur in your county. We're not a federal. The Watchman already had back in May a picture of the same thing. Come on. Plus the Mackinac Island pictures. Are you kidding me? You're going to see Eric had no intent to do anything in criminal in Antrim County. You're going to see they don't have venue in Wexford, which is Cadillac. No criminal acts occurred there. You'll see they have no venue in Lake County. That's Luther, Michigan. No criminal acts there related to Antrim County either. And no criminal acts in Antrim. It's one video. He said a few things. That they're going to know anyway. This is why they picked this spot, not the Mackinac Island spot, not the Lansing House. They picked this spot. It's in the middle of nowhere. It's not near the police. By the way, police, they're usually out at night anyway, and they're not at the post. That's when they're cruising around looking for people that are drunk or doing nefarious things. He did nothing in Antrim County that's worthy of a conviction. And he looked at those pictures and you listened to Mr. Ralston this morning. Man, did that sound bad? They didn't talk to Eric before they arrested him. So venue, I want you to look at the venue instruction. Mr. Ralston went a little bit on. I have to too. I got to match that. I got to tell you, it's like a closing argument. I'm sorry. But you're going to see instructions. They're like those little cookbook things, recipe, laundry list. Got to have them all. One of them is venue. Ask yourself what happened in venue. This is a state case, which means you got to do it in this county. He said a few things. You're going to see some comments he made. Talked about, hey, the police in Grand Rapids, if there's only one cop out, well, think about it. How many cops are out in Grand Rapids? One cop? One policeman? One law enforcement officer? Are you kidding me? Grand Rapids is a metro city. There's hundreds of police cars out. He was just saying things. He's going to explain it to you. Ask yourself, and they did. They came up a second week. Adam brought some people up. Same foolishness. No plan, no agreement. They're driving around aimlessly. Eric went to that went to that FTX show on February 12th, was never told anything about any trip. This is the guy who had eyes on. He's got binoculars that work at night. He's going to have some cool tools he's going to show you. He would have been very helpful to them. Didn't go, wasn't told. Wasn't invited. Why would you not invite the guy you took the last week? Show him where it was. They knew why. They knew why too. Eric's pled not guilty because he is not guilty. The facts will not show him guilty. The instructions are going to give you where you're going to be, give you a place where you're going to be required under the law to find him not guilty. They had a second day of Luther, FTX. My guy went out and he did a little more training. What do you want to talk about the first day? And the RF device. I'm jumping over a little bit, I'm sorry. But the 12th, when Eric got there, he brought the device. And he hands it over to Adam. Here it is. You wanted it. Here. Doesn't know this training's for any bad purpose. He thinks it's the crazy, malicious, paranoid, nervous people. And they're just going to do what they do, which is, hey, got a phone on you? Buzz, put your phone back. No cell phones. So he hands it to Adam. He watches Adam walk over and hold it to a guy's phone that's sticking out. It works. Only like that. That's how great this thing is. And then Adam went off. He saw him wand a couple people. Nothing happened. And then it was gone. Adam eventually came back, said, Eric, go wand people for me. You know what Eric did? He shut it off, put it in his pocket, and left it there. And he left it there that day when he left, after his training, put it on his table. He had a table with all, I'll call it junk, but it's his goods, his training stuff, the things he loves and lives for. He left it there. He didn't take it to Walmart. I think they're talking about him meeting them at 10:30 in the morning at Walmart. Well, Eric didn't make it. He was late. But some guys went to Walmart later that night. Eric went out there. He smoked some more marijuana. He wrote a note to him, says, I'm going to drill one. Apparently, that means rolling up a doobie. Because he went out and smoked with Adam. Adam hopped out of a car, and he got him high again, because Adam has no marijuana, no money. Living in a basement of a vacuum cleaning store. And he had a trap door. They're going to make it sound real scary, but he had a door that goes through the floor, which is a trap door. This guy had nothing. So Eric got him high. And then Eric went back and stayed with his kids, his mom, and had nothing to do with any ride, didn't know they were going. Apparently that's where they met later on. And Eric didn't see any of that. But he was there. He didn't bring out the RF device. He left it back there. If it got out to Walmart, if Adam used it to wand some of these guys, Steve was there, for example, on this ride. I talked to you about Steve. There was 4 out of 11 were the government, either agents or informants. They can basically put on the thing just like they did before. But Eric didn't know about that. Now I think I'm getting to Sunday finally. Eric shows up, regular training, everything's fine. There was a meeting there, some talk, people left. I mean, it was not anything to do with Eric. He's got nothing to do with this. He goes back to trains, finishes his day, and goes home. Next thing he's hearing, hey, October 1st, there it is. Dan, after a month, Dan reaches out. Hey, how about that ride? And Eric's thinking, you gotta be kidding me. Who is this guy? Is this guy a crook, a criminal, a killer? What is he? He's coming back to him. What you think of the ride? So Eric starts doing what Dan did. He's playing with him. Oh, that was great, great. He starts throwing out some ideas and things just to see. He's fishing them. Eric was going to go to the police if he found out what they were doing. He wasn't going to send people down the river and be wrong about it. So he was toying with Dan, who finally came back a month later. Why did they wait so long if Eric's in this thing? He's toying with him, listening to him on the text, going back and forth. This is the last thing that happened, October 1st, October 7th. It's when the arrests were. I gotta ask you to watch the exhibits as I get ready to close here. They're gonna put up incomplete exhibits. They're gonna be exhibits that are out of context. I want you to watch for that. There's one that Adam says, hey, is anybody up for kidnapping? Okay? And they'll come in and say, Eric Molitor is engaged with a cryptic chat that kidnapping's discussed. Eric's working at a Menards. His phone is blowing up in his pocket. He doesn't see it. They self-delete, and they don't bring in the whole text. No, Eric never responded to this crap. Then he said something else about maybe I should have said snatch and grab, and people are laughing, little smiley emojis. He didn't see it. He's not engaging in a chat. It's a misrepresentation. I'm going to bring the full exhibit so you can see the other two lines, so you can see where it stops. And you'll know that Eric Molitor never wrote back after that, never saw it. He saw it when he got to jail, when he was arrested in jail for a short time. He read his reports. It's like, oh my God. He's shocked when he got arrested. Didn't know he did anything criminal. If you're going to do something criminal, wouldn't you have the intent? Wouldn't you know you did it? You do a B&E, you know what you're doing. This guy had no heads up. These guys have what I call FBI goggles, and they are laser pointing here. They're doing their job. They're trying their best. They blew it on this kid. They blew it. They misrepresented things. They have so far in this case, and I think you'll see it. Eric didn't go on October 7th. At first he said he did. Free gear. He's going to get a free ride, go down there. He had no money, is what he told him. I have no money to go get free gear. He just made up an excuse. He's just saying things to get these guys out of here. He didn't go down there. There was some talk about, hey, they're going down to get a bomb. Adam wasn't going to do this thing before the election. This thing was not going to come up in that election year before November until it was pushed. October 7th is the arrest date. Put the math together. There's some politics going on here. The governor was told about this the whole way through. The whole way through. And when these arrests come down and these things come down, she's out there blaming Donald Trump. This is Donald Trump. It's all politics, folks. There's something going on here. I don't know what's going on. It looks like weaponization of the government. It looks like politics. The timing. They weren't professionally planned to do this. There was some kind of scam put together where they were going to go down and buy a bomb for $4,000. And that didn't work. Adam had no money. I think he talked to people, hey, can you get money? Because they did stop on that second ride, and Adam got out with Dan, who's an agent, and they looked at the bridge. You think these guys could blow up a bridge? Barry Croft couldn't blow up a little firecracker. He was doing that in front of his kid. In fact, the second one he did make a noise with. They're blaming Eric as being the medic in that case. He's back hiding behind the vehicle with Steve, crunching down, scared to death. He did probably say, if anyone gets hurt, I'll try to help you. But, you know, you guys are idiots. He went and hid behind a truck with Steve, with a red truck. I can't keep up with all the misrepresentations here. I've hit most of them. I'm out of line in a few of them. But I want you in the end to look at intent. I want you to look at the instructions. Was there intent by Eric to intimidate or coerce a civilian government? Is this the guy? Influence or affect conduct of government? Intent to coerce, to intimidate? A lot of this stuff's free speech. I mean, if Dan can sit there and tell these people to shoot a gun to her house and send shells there, and that's not criminal, then this isn't. And you'll hear why he said these things. Why are we in the state court anyway? The FBI. Think about these things. I've enjoyed actually working with these guys. We're not on the same side. We're going to be colleagues and so forth. This came out in the federal case. Somehow they got Hank on tape. He said, Don't let the facts get in the way of a good story, right? He's talking to Steve Robeson when he goes over to have him say, are you going to kill a human source? This somehow comes out in this conversation, and it showed up in some pleadings. I don't know what, he's probably joking and saying what people like to because they're under stress and they say things, but he said this and it's on tape. Don't let the facts get in the way of a good story. If you sit and just listen to those facts and watch them, what they put up there, oh my God, this is terrible. That's what you come up with. Listen, please, listen to the other side. Eric has one. He's going to testify. He's going to provide facts that you will believe, that make sense, that follow the exhibits. He embraces the exhibits. Bring him in. This is so wrong. I want you to think about showing that the facts matter. You can do that by returning a verdict of not guilty, because that's how the instructions work. That's where the facts are. That's your duty. You've been sworn in to follow the law, to find the facts, to be impartial, fair and impartial. My God, how many times do we hear that? Can you do that, please? Can you listen to both sides? Can you give this young man, I call him a kid because I'm 64, he's 38, give him a chance. Let him tell his story. The story he didn't get to tell the police before they came and did their takedown with 40 cops at his house holding guns to his family. They're going to fall short. They have a burden. They have to prove Eric Molitor guilty beyond a reasonable doubt. He's not guilty. Just be patient, please. And thank you for listening. I'm sorry I've broken the record here. It means a lot to this system, to the people of Michigan, the United States of America, for you to do your duty and do it honestly, fairly, and justly. The correct and accurate verdict in this case will be not guilty. Keep that in mind. And yeah, there's no evidence, but you're hearing a spiel. And I just want you to wait and see what spiel turns into facts. I think you'll be surprised. Thank you.
Thank you, Mr. Porter. Ladies and gentlemen, we're going to take a short break, probably 10 to 15 minutes, to give everybody a chance to refill any coffee, water, bathroom break, all that kind of thing. Take the time you need, and then we'll bring you back and we'll begin with the prosecution's case in chief because they have it. All rise for the jury. Okay, let's go back on the record. Everybody can have a seat. Thank you. The record can reflect the jury is out of the courtroom. Anything that we need to take up before we go to break, Mr. Walton?
Can I be heard?
Yes.
Yeah, I'm a little concerned. It's entrapment. He's arguing that, I'm talking about Mr. Barnett now. He's obviously arguing an entrapment defense to the jury. Okay. I have over 20 instances in my notes of him, alleging entrapment arguments to the jury. I'm going to ask for two things. Moving forward, I'm going to tender a proposed curative instruction to the court tonight on that issue, and ask that the court instruct the jury that entrapment is not a defense. It's an issue of law for the court to decide. It's not a factual issue. And also moving forward, I'm going to be very aggressive on Mr. Barnett in objecting to these kind of questions during the course of the trial. It's unfair to try to pose what he knows is a legal defense, trier fact. And with those two things in mind, I don't really have anything else at this moment, but it's concerning, and I think he's trying to poison this jury to a certain extent, and I was a little surprised.
Thank you. Mr. Nunzio, anything for you?
No, thank you.
Mr. Saber?
No, thank you, Judge.
And Mr. Barnett?
Your Honor, I'm stating facts that are in the police reports. They're facts. Everything's a fact. They don't want to hear the facts in this case. They do matter. These are facts. I never once said, excuse him because of entrapment. Never. This is just facts. I'm explaining the backdrop of this case and how it's been.
You didn't say the word entrapment, but there were a couple of times in my head where you said that the FBI did the training. You said that the FBI was the XO. You said that CHS Dan is the one who organized these guys and did that. So if it didn't cross the line, it certainly got right up to it.
Sure.
Hang on. I'm not done. So, going forward, you are allowed to present facts. When you say that CHS Dan is the one who did the training, that is describing the FBI as having entrapped your client. That is a legal defense, not a factual one. And entrapment will not be presented to the jury. Is that clear?
It is, Your Honor, but I just respond politely here. Sure. My client was not involved ever that I know where Dan was training him. And my client is very trained at this stuff. He's not being trained. He's just going through shoot house. I don't believe Dan ever trained him.
Okay.
It doesn't apply to my case. I'm just telling the entire backdrop of this whole situation.
I use that as an example. I didn't write down the instances, as Mr. Wilson indicated that he did. That's the one that just stuck in my mind. There were others. So let's just be very clear going forward. No entrapment. That is a legal defense, not a factual one. It will not be argued to the jury. It would be perfectly appropriate for another party to object, and the court will deal with it instant by incident. Okay? And relative to the instruction, the people can obviously propose that, and the court will make a determination at the appropriate time. Anything else for the people?
At closing, I typically don't object a lot during opening and closings, but I will be objecting a lot if he does this again in closing.
That's up to the parties to decide, and the court will deal with it. Anything else for you, Mr. Berman?
Yes, Your Honor, I'm going to ask, and I did ask the jury to find him not guilty. I didn't say that he committed a crime. Instead, he did not commit a crime. He's not guilty. I didn't say he did it, and you need to excuse him for doing it because he did a crime. He didn't. I argued he didn't meet the definition. He didn't meet the venue, and he didn't meet materiality because it's a duplicate video. This is all in the instructions and nothing to do with entrapment. I'm sorry I had to tell the whole story that's not being told here, but those are my defenses. Venue, materiality, and the definitions. What's a fit? Is it an asset? Is it worthless? Is it a material asset? Are they in the right venue?
Okay, we're not arguing and redoing your opening for the purposes of this discussion. You listed a number of things to include venue, to include the fact that the elements weren't met, and a variety of factors. What we're talking about specifically are things relative to entrapment. And in the court's mind, if you didn't cross the line, you came right up to it and were arguing entrapment. That will not be tolerated in the future. I'll make a determination relative to the curative instruction, and a party can object as it becomes necessary. You've made your record. Anything else for you, Mr. Nunzio?
I'm standing up and saying, no, Your Honor.
Anything else for you, Mr. Sutton?
No, thank you, Judge.
Okay, let's take a break. We'll take a break until 4:00. Thank you.
All right.
If I need these, I'm in big trouble.
Hey, you never know when the mood's gonna strike.
let's go back on the record. The jury is still outside the courtroom. I did ask Mr. Arden that she distributed those initial instructions. She left one on each chair, basically. Mr. Ralston, anything we need to cover before bringing the jury back?
No, we're going to get into testimony, obviously, and some exhibits. I do have a couple of, I have 4 actual exhibits, of the exhibits that I think I'm going to enter this afternoon. Got 4 of them that I've got individual printouts for the jurors. It's hard for them to see the detail and timelines and communication summaries that we're going to admit. We're going to do the best we can with TV, but I'd like to be able to publish those once they're admitted.
Sure. And obviously subject to them being admitted once they are.
Right.
That would with any of the parties, if they want to distribute paper copies to the jurors. That would be perfect.
Okay, thank you. Yeah, and you have an exhibit book also?
And I think one was distributed to each of the parties at lunchtime. I think.
Yeah, I think, we've got 2 of them over there somewhere. But yeah, there's one and there's one, you know.
Okay.
We're sharing.
And also, I talked to Ms. Nunzio during the break. A little difficulty with the upload, her accessing it, I understand. I've detailed Mr. Grano and Special Agent Ferris to assist her in getting access in there. What they have is from a previous delivery that we made, it's 95% correct, but to get them the most recent electronic information, and I was just made aware of this during the break, we're going to get her access to that. Yes, sir.
And that would be the one drive so that she could access basically this version.
Exactly, the most recent version, yes. Okay.
That's known for the record. Mr. Nunzio or Ms. Nunzio, anything up to you?
That is correct. It's just an issue with a verification code being sent, and we're trying to figure out why that's not being sent, even though technology says it's being sent.
Sure. Well, heck, we all know from research on Monday, technology is great when it works. Mr. Cyber, anything for you before we bring the jury back?
Judge, I'm not sure or clear, look for you for some direction on how to handle the 343 objections on the exhibits.
Well, as I indicated to the parties, part of the reason that the court had them file any objections such as those was so that, in my opinion, now they're part of the record and they are noted. That doesn't remove the party's possibility from objecting during the process of trial. I think we certainly can. I just wanted to give the parties an opportunity to make it part of the record prior to the trial in case they didn't want to object each time. You could simply indicate when asked about its admission that it's subject to the objections that are already part of the record. Obviously, we understand that those are taken into account.
We would ask the court to not allow any demonstrative evidence at this point. If no evidence has been produced.
Okay, well, if the demonstrative piece is sought to be admitted, then we'll deal with it at that time.
Thank you.
Mr. Nunzio, did you have something?
Yes, and forgive me for going out of order, Mr. Barnett. Can we concur those objections, or are we now timed out by virtue of the court's order? Okay, so we're just gonna register a concurrence on those objections, and as the court indicated, we'll deal with it as the exhibits. So
And when you say concurrence, you mean in the exhibit and objection that was filed?
that's correct.
Okay. Mr. Barnett, do you also concur with the written filing?
I do. I only have 3 exhibits or meetings that I was going to object to. I wanted to look at the numbers right with the and see if I can find what's been.
Oh, that's fine. I mean, that's fine. We can do that as the exhibits come up. Anything for you before we bring the jury back?
No, thank you, Your Honor.
Okay. All rise to the jury. Ladies and gentlemen, welcome back. As I told you before the break, the statements, and the next part is obviously the case in chief of the prosecution because they have the burden of proof in this case. So we turn to Mr. Walton. Mr. Walton, your first witness.
Thank you. Special Agent Henrik Ipler.
Watch your step there.
Witness stand. Before you get seated, sir, would you please stop and raise your right hand? Do you swear that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
I do.
Go ahead and take a seat for me. And once you get situated, sir, if you can tell us your full name and then spell your last name.
Sure. My full name is Henrik, Henrik, Impola, I-M as in man, P as in Paul, O-L-A.
Thank you, Judge. Good afternoon.
Good afternoon.
Can you introduce yourself to the ladies and gentlemen on the jury, please?
Good afternoon. I'm Special Agent Hank Impola with the FBI.
Your spelling is that your true name is Henrik, is that correct?
That's correct.
Okay, and most people call you Hank?
Yes, sir.
Okay. Mr. Impola, you indicated that you're a special agent with the Federal Bureau of Investigation, is that correct?
That's correct.
Let's talk a little bit about before you became a special agent. Can you tell us a little bit about your educational background?
Sure. So I went to Michigan Tech. I graduated ultimately with an engineering degree. I worked as a mechanical engineer in commercial construction as a project manager before getting into law enforcement, the FBI.
Okay. And can you tell us what year you joined the FBI?
2010.
Okay. And can you kind of walk us through a summary of your different assignments that you've had?
Sure. So after basic training at Quantico, which all agents go to, I was assigned to the Detroit field office. I worked for my first 3 years on a terrorism squad in Detroit. And then for the next 10 years, I was a terrorism agent out of the Flint Resident Agency, which is a satellite office. There's 10 agents in Flint. In 2022, I was assigned back to the Detroit field office and as a supervisor of a counterterrorism squad.
Okay. You said counterterrorism. I mean, how much of your work since 2010 has been in the terrorism investigation realm?
So for all 13 years of my career, my primary assignment has always been counterterrorism. For a period of 5 years, I ran a violent crimes against children task force, which was extra duty out of our Flint office. So I worked on juvenile sex trafficking. Flint's a small office, so everybody contributes to the violent crime in the city. But for my entire 13-year career, it's always been counterterrorism investigations.
Does terrorism break into different groups or different types of investigations? Can you tell us about that?
Sure. Yes, it does. So for terrorism, you have international terrorism and domestic terrorism. And under domestic terrorism, you've got white supremacy, militia extremism, black separatism, anarchist extremism. So how the FBI does it is we look at the ideology behind why the attacks are going to occur.
Why is the ideology important?
Terrorism is a messaging crime, so it's a crime intended to send a message to the population or to the government. And so the goal of the FBI is to stop the terrorism attacks before they occur. So for that, you have to look at the reasons people would want them to occur. And you try to see who's building up towards that attack, and then hopefully you stop it before anything bad happens.
Did you have any other ancillary duties during your assignment in Genesee County and Flint during those years?
Yes, sir.
Tell us a little bit about that, if you would, please.
Well, for about 5 years, I was a medic on our SWAT team. I previously had some training as an EMT through the local fire department. And then for 12 years, I was a member of our evidence response team, which is another ancillary duty where you respond to crime scenes around Michigan and you collect forensic evidence.
Your current assignment, expand on that just a little bit in terms of what it is.
So currently I'm a supervisor of a counterterrorism squad out of our Detroit field office.
Okay. And if you will, tell us, how does the FBI come to be involved in investigation in general?
Sure. So generally, you receive a complaint or some sort of information. What the FBI is looking for in domestic terrorism investigations is what we call a threat to national security. So if it's a threat of violence on behalf of ideology, and we look at that threat, and then we try to determine how we can disrupt or dismantle that threat.
Okay. In terms of, the FBI and being involved in a state case, I mean, is that unheard of?
Oh, no. We work with our state and local partners all the time.
Okay. This particular investigation, did the FBI partner with any other organization?
Yes, we partnered with Michigan State Police, who's on our joint terrorism task force, and we worked this case jointly from the inception to the end.
Okay. Can you help the jury to understand from a global perspective or from, 30,000 feet, what your role was in this investigation?
Sure. So I had a number of roles. Initially in this case, I was a CHS handler or a source handler for CHS Dan. That's how the case started. Then as the investigation progressed, I became a case agent for what we call a terrorism enterprise investigation, which was against the Wolverine Watchmen. So after I became a terrorism enterprise case agent, that means I was responsible for the threat posed by the Wolverine Watchmen. I helped initiate an undercover operation. And then I was the case agent for that undercover operation. That was called Operation Cold Snap. So that was kind of the general premise of my involvement. Obviously, there's a lot of specific tasks within that.
Sure. And can you help the jury to understand the time frame of when you became involved in the investigation?
Sure. So I first learned of the Wolverine Watchmen on March 17th, 2020, when we had a complainant come to the FBI.
Okay. And was that, in fact, CHS Dan?
Yes, sir.
Can you explain to the jurors what those letters mean, CHS?
Sure. It stands for Confidential Human Source. So in the FBI and in the federal government, we've got an acronym for everything. And CHS is the acronym for what would be on the state side, a CI or a confidential informant. It's the same thing. It's a lay person who is acting on behalf of the FBI without any training.
Okay. In terms of, you said you were the case agent for the undercover portion of this investigation. Is that correct?
Yes, sir.
Okay. Do all investigations involve the use of undercover special agents from the FBI?
No, absolutely not.
How is it? Tell us why. Why is that? I'd like you to explain to the jury the nature of using an undercover special agent.
Well, undercover agents they're dangerous. So you're putting a law enforcement officer in harm's way. So only a small number of cases would involve an undercover, and that would be because the danger to the public, as that escalates and the case escalates, then law enforcement would have to escalate our techniques to try and mitigate that danger. So in this case, as the threat streams merged and the danger increased, we introduced undercovers, which we call a sophisticated technique to try and mitigate that danger.
Okay. We'll talk more about that, I'm sure, as we go along. Tell us, if you will, during when did the investigation conclude? I mean, you told us that it started on March 17th, 2020. What was the concluding date, if you will?
Well, the arrests happened on October 7th, but the investigation for us is still open. We're still looking into, it's an open investigation.
Sure.
And then we're continuing to work and produce evidence and support the prosecution here.
Okay. In terms of, you being the case agent here, tell us a little bit about, during the course of the investigation, what type of evidence do you look for?
Well, during the course of the investigation, we're looking for subjects who are willing to commit violence. That's the big thing. Anybody who's willing to put themselves at risk and to put others at risk.
Okay. And what types of, do you look for electronic evidence?
Oh, yes. Yes, so we look for electronic evidence such as that you'd find in online chats like Facebook or Instagram. We look for electronic evidence that you'd find like on a personal cell phone, like a text message or an encrypted message that's sent on the cell phone. We'd do things like physical surveillance, so we'd watch and verify what happens. And then in this case, we did a lot of audio recordings with our undercovers and sources so that we could hear ourselves what was happening. We made the recordings, and then also we transmitted them and listened to them live as the events were occurring.
Okay. In the recordings, how does that happen? How do the recordings occur?
Sure. So for a CHS or for an undercover, as a handler and an undercover agent, I would provide a recording device to that person who's going to be in contact with any subjects. And then when I would turn that device on and I would listen live during the course of that training or that meeting. And then when the training or the meeting is concluded, I would meet up with the source, retrieve the source or the undercover agent and retrieve that device and turn it off. And then I would take that electronic evidence from the recording device and I would enter it into evidence. And then I would listen to it, and also I would debrief the source or the undercover as to what they saw, any observations that they heard, what had occurred during the meeting.
Why do you do that? I mean, why do you debrief somebody like CHS Dan after they attend a particular meeting or event?
Well, the short answer is I'm trying to get it right. I'm trying to understand what happened. I listened to the event. I tracked the source or the undercover as they moved their location. I wasn't personally there at the event, and so the sources and the undercovers are the ones who witnessed the event. Also, a recording device captures as much as it can, but sometimes there's noise from clothes, or there's loud gunshots, or there's crosstalk. So sometimes the context of those conversations are important. So you try to record as much as you can throughout the duration of the event, and then gather all the information that's context for what actually happened.
I want to go back a little bit when you were talking about the undercover agents. And I think you testified there that the undercover agents are dangerous. I mean, I think maybe I misheard you, but is that what you meant? Are undercover agents dangerous?
I'm sorry if I said that, I misspoke. The undercover agents are placing themselves in dangerous situations.
Okay, fair enough. Well, let's talk about like things like Facebook and Instagram and phone records. Can you just go out and get these on your own?
No, sir.
Okay, can you tell the ladies and gentlemen on the jury what protections are in place? What do you have to do to meet legality, to meet constitutionality, to look at those kind of things?
Sure. So what you do if you want to look at somebody's Facebook records or their phone records is have to write a search warrant. So I have to write an affidavit with probable cause and present that to a judge as to why there might be evidence on that facility, as we call it, of a crime. And then once the judge signs the search warrant, I would send it, for instance, to Facebook or whatever electronic provider they have to try and obtain those records and then collect those records as evidence. For a phone, once we receive the search warrant, we would do a forensic extraction of the phone dump, and then I would look through the phone dump record. So that's everything that's on the phone that's extracted, and then I would collect the evidence from that phone dump, as we call it.
Okay. In terms of the documentation, how many search warrants did you seek in this case for different things? Or how many devices did you cite? A better question would be, how many devices or accounts did you seek permission from a judge to look at?
There was quite a bit. So for instance, for Facebook, I believe I wrote 5 to 7 search warrants encompassing 57 different Facebook accounts. Then during the course of the investigation, there was over 20 search warrants for phones. And then also during the arrests, there was individual premises search warrants. Premises is the location where the subjects live. And so over the course of the investigation, this is a rough guess, but probably somewhere between 75 to 100 search warrants.
Okay, and each one of those seeks the judge's permission to do, what you want to do in your investigation, is that correct?
Yes, sir.
Okay, and in terms of you talked about the returns, what you received back from Facebook, I think you said, and the different cell phone providers. In terms of, like Facebook, how many pages of Facebook records did you receive back?
Well, for each one of those 57 accounts, you generally get 10,000 to 20,000 pages of PDF records. So it depends on how much that user posts, how much content they have, how much they use that application. But they're fairly lengthy returns.
Okay. Who's responsible for going through that?
Well, me and my team are responsible for doing that.
Okay. And in terms of, you said there was recordings that were part of the evidence in this case. I mean, roughly how many hours of recordings were made?
So a rough estimate would be over 150 hours of recordings.
Okay. Now, tell us, if you will, and who's responsible for going through all those recordings?
Me and my team.
Okay. And have you listened you personally listened to all the recorded evidence in this case?
Yes, sir.
Okay. And are you able to identify the voices of the defendants that are here in court today?
Yes, sir.
Okay. Do you see Eric Molitor in court today?
I do.
And can you tell the ladies and gentlemen where he is?
Sure. So he's on the far right of the table, right here in the dark gray shirt next to his counsel, Mr. Bill Barnett.
Okay. And do you see Mr. Michael Knoll in court today?
Yes, sir.
Can you point him out for us, please?
So he's third from the right here. He's wearing a suit with a blue tie next to his counsel, Mr. Tom Cyber.
Okay. And I know I'm blocking, but do you know if Bill Knoll is in the courtroom?
Yes, he is. Okay. He's right here next to Christina Nunzio. He's wearing a purple tie and a dark suit.
Identifying the defendants for the record, Your Honor.
No objection. No objection.
No objection, Your Honor.
Thank you. During these 150 hours of recordings that you've listened to, I mean, have you learned the defendants' voices?
Yes, sir.
Okay. And have you learned maybe the different names or nicknames they go by?
Yes, sir.
Okay. And let's talk about the recordings a little bit more. Why do you record?
So we can try to capture all the words that are spoken, so that we can determine who said what, whose idea, who brought up what idea, what statement was made at what particular time. We're trying to understand exactly what happened.
Okay. Tell us, if you will, did you have any other ancillary duties associated with this case in terms of discovery?
Yes, sir. So one of my jobs in this case was to produce discovery throughout the entire investigation.
Okay. And what is discovery?
So discovery is the records that are compiled by law enforcement, so Michigan State Police and the FBI. So these are our reports, our audio recordings, the phone dumps that I was talking about, the Facebook returns. So everything that I use to compile the exhibits and compile the evidence and present to the prosecutors, that is produced to the defense. And so in this case, that was one of my jobs, was to compile all that and everything that we used and give it to the defense.
Okay. Tell us, if you will, what started this investigation?
Sure. So CHS Dan was a complainant who came to the FBI on March 17th. So when I met CHS Dan, he described the Wolverine Watchman and their plans to do no-knock raids and kill law enforcement officers in Michigan. He provided consent for his phone so that I could see the messages and verify what he was talking about and who were the leaders of the Wolverine Watchmen. And so that instance, that was March 17th, that was kind of the genesis of the Wolverine Watchmen investigation, which then led to these threat streams merging, these other individuals coming in.
Okay, and by other individuals, who are you thinking of?
So I was thinking of Adam Fox and Barry Croft, and then ultimately members of Adam Fox's team, Mike Null, Bill Null, and Eric Mauder.
Okay. Can you tell the ladies and gentlemen of the jury, you talked about the Wolverine Watchmen, being the center of your focus in the beginning because of Dan. Where did the Wolverine Watchmen, was there some geography associated with them? I mean, where were they from?
So the leaders of the Wolverine Watchmen were from Jackson County. They were a anarchist militia there, and they assembled regional quick response forces or teams locally in the areas that they lived. But their training grounds and primary location was Jackson County, Michigan. So Munith was the founders, Joe Morrison and Pete Musico, that was their residence and training grounds.
Okay. Agent Impola, have you heard the word boogaloo before?
Yes, sir.
Okay, and can you tell the ladies and gentlemen on the jury, what the meaning of that word is?
It means civil war.
Okay, and who uses that?
Well, Boogaloo boys, or those who believe in the Boogaloo, or Mujahideen fighters, those who adhere to the Boogaloo movement, they use the term Boogaloo.
You said Mujahideen. I mean, is that a play on words?
Yes, it's a play on the word Mujahideen.
And what's that?
Mujahideen is a term used in Islamic terrorism to talk about somebody who's a martyr. They're willing to die. And the concept is that they would go to heaven if they are killed in battle.
During the course of your investigation, did a gentleman by the name of Adam Fox come to your attention?
Yes, sir.
Okay, and tell us a little bit about that.
Learned that Adam Fox was selected to be the Michigan commander of the 2nd Continental Army. That was a position that Barry Croft gave to him. So he was Michigan's representative in trying to kick off the Boogaloo, so start the Civil War.
You mentioned the name Barry Croft. Why don't we talk about him for a moment? Can you tell us a little bit about him, please?
Sure. So Barry Croft was a national figure in the 3% movement. He'd been in the militia community, or the anti-government community, for many years. He had quite a large following, and he started the 2nd Continental Army. His concept was to bring about the Boogaloo by attacking governors across the United States.
So we've talked about the Wolverine Watchmen a little bit. We've talked about Adam Fox and Barry Croft. Did Adam Fox ever connect with members of the Wolverine Watchmen?
Yes, sir.
Okay. And give us a brief overview of that.
Sure. Barry Croft sent the Wolverine Watchmen, talked to members of the Wolverine Watchmen. He talked to Adam Fox, and he told them Barry Croft told Adam Fox that he was sending him some boys from Michigan. Ultimately, Adam Fox met with members of the Wolverine Watchmen and trained with them on 2 occasions in Munith in Michigan.
Okay. Did you create an exhibit for the jury's benefit that shows the subjects of the investigation here?
Yes, sir.
You've got a book in front of you there, and it's got over a couple of hundred exhibits in it. Why don't we start there? On page 1, can you tell us what proposed exhibit number 1 is, please?
Sure. So these are subjects of the investigation that are pertinent to this case in Antrim County. Obviously, this was a large investigation. What I did is I took driver's license photographs of individuals who would be referenced in my testimony and in the exhibits that were selected as evidence. And I put them all on a chart so that we could visually represent and use that as a testimony aid.
Okay. The subjects there are members of the Wolverine Watchmen included.
Some of them are, yes.
Okay. And is Barry Croft and Adam Fox included?
Yes, sir.
And are 3 defendants included as well?
Yes, sir.
Okay. And Judge, I'm going to move for admission, please. Propose exhibit number 1.
Let's go to the defense.
Yeah, we would object, this is not a complete list of the subjects of investigation. There are individuals that are left out. Court wishes counsel to voir dire this witness with respect to subjects that are left out. We would welcome that opportunity.
You're asking why are the witness relative
To the exhibit, absolutely.
Okay, go ahead.
I see the exhibit and it's been provided to us, thank you. The subjects of investigation is more extensive than the 14 you have in the exhibit, correct?
Well, the subjects of investigation, there's certainly more than 14 subjects across the terrorism enterprise investigation.
Where's Concerta's name and where's Dan Harris's name?
So I selected individuals here that relate to this story. I tried to narrow it down to the individuals that we'll be talking about who participated, that we felt, or that I felt, played a significant role in the case and that were involved in this county's charges.
So how many individuals, so there were additional individuals subject to your investigation that are not in this photograph, correct? Or in this lineup, so to speak?
So there's a number of FBI investigations. There's investigations out on the East Coast. There's investigations in different states that I wasn't part of, but there's quite a few individual subjects who were investigated as a result of this this incident.
Maybe I didn't make myself clear, forget that. You invested the case involving Jackson County, the Wolverine Watchmen down there, correct?
Yes, sir.
And that was part of this investigation, correct?
Well, the Wolverine Watchman was the genesis of how we got here, how Mike Null, Bill Null, and Eric Molitor were identified, but that's a separate investigation involving separate charges with different motives, different stories. So clearly there's some overlap in some of the stories, but I selected the members of the Wolverine Watchmen who continued on with the plot, had some sort of involvement, and that I would be referencing throughout my exhibits.
So essentially, you've narrowed down pictures relative to this investigation, excluding those from the federal case in Grand Rapids, and excluding those in the Jackson County case that transpired earlier, correct?
So what I did is I selected individuals who are pertinent to the evidence that I'm going to be presenting.
My question was, have you left out the individuals from Jackson County case and federal case, yes or no? And how many of those individuals have you left out? Because Mr. Ralston had asked you the investigation. It was not confined to the Antrim County investigation. And so this just says subjects of investigation. It doesn't say subjects of the Antrim County investigation. So my question to you is, why have you left out names of individuals subject to your investigation from Jackson County in the federal case out of Grand Rapids Western District?
I'm sorry, which individuals are you referring to?
I'm asking you.
Hang on 1 second, I don't mean to interrupt Mr. Matthew, I just want to make sure that we get the information. So his first question was, the individuals involved in the case, federal case in Grand Rapids, and then the case in Jackson.
Sure.
Are there individuals that were involved in either or both of those cases that are not?
So for the Jackson case, Joe Morrison, Pete Musico, and Paul Bellar were charged. Those are members of the Jackson charges down there.
Okay.
And they're on the chart here. They're the lower 3 members of the chart.
Okay,
So just
and then
three-
for Grand Rapids, sorry.
So for the federal charges in Grand Rapids. You've got Barry Croft, Adam Fox, Caleb Franks, Ty Garbin. Those members were charged federally, and then Steve Robeson was charged federally in a different case in Wisconsin.
Okay, Mr. Nunzio, go right. I apologize.
No, thank you, Your Honor, thank you for that clarification. Well, Mr. Concerta and Mr. Harris were involved on the surveillance, the daytime surveillance that we heard about in opening argument, correct?
I'm sorry, who?
Concerta and Dan Harris.
No, they were not involved in the daytime surveillance.
But were they at the FTXs or anything involved in any of the Luther case or the?
They were at the Cambria, Wisconsin FTX, and they were at the Luther, Michigan FTX.
Okay. Then the Luther FTX is part of your investigation, correct?
Yes, sir. And if it helps, I've prepared a different chart for the Luther FTX with all the subjects who were there.
Thank you. No more questions, Your Honor.
Okay. Mr. Sauer, any thought here for you?
Yes, briefly. Agent, you said you're the evidence holder or keeper.
I collected we call them Elsher recordings, so electronic recordings in this
Holder or
case.
keeper of the electronic.
Yeah, I'd ask to allow the witness to finish his answer and not cut him off.
Okay, I didn't receive it, Mr. Sauer, did that, were you done with your answer?
Yes, sir.
You used another acronym, I think, right there. Could you say it again?
Sure, it's Elsher. So it's electronic surveillance. That's what it stands for. And so for us, that's all the recordings made by the undercover. So I was the one who accepted custody of the recording devices and then entered them into evidence.
Is it ELSUR?
ELSUR. Yes, sir.
Thank you, Mr. Sauer.
Thank you, Judge. Agent, you're not a personal witness to either of the charged counts in this case. You're not a witness to providing material support to a known terrorist or a witness to possession of a firearm by any of these three defendants in this case, are you?
No, I'm going to object. This is outside of order, Judge.
Mr. Sauer, we need to confine this to close count.
Agent, would you agree that these pictures are confusing as they contain only selected individuals from three different areas?
I would disagree. I tried my best to not be confusing, and then I provided other charts with different pictures to describe the Wolverine Watchman, the Luther FTX, different events. I categorized those separately, and I did my best to not confuse anybody.
But the Wolverine Watchmen are not on trial here.
Judge, we're outside of the scope of order here.
Mr. Sauer, thank you. Any additional questions?
No, Judge.
Mr. Barnett, any questions relative to what your proposed people proposed?
Just real briefly, of the people that were charged at the beginning of this, and on October 7th, you left out Brandon Caserta and Daniel Harris from this picture, right?
So Brandon Caserta and Daniel Harris, who were charged in federal court, are not included in this picture. They are included in the Luther FTX timeline where they participated. They're also in pictures from Cambria, Wisconsin, where they participated.
Okay, but they were subjects of your investigation, were they not?
They were subjects of the Wolverine Watchman investigation, which is not what this chart represents. It has some members of the Wolverine Watchman who moved on as the threat streams merged to tell this story. And they are part of the Wolverine Watchman chart that I provided in these exhibits. I'm sure we'll get to.
Okay, but these are subjects of your investigation.
These are subjects of the investigation who are pertinent to the charges in Antrim County.
Okay, but you were in charge, officer in charge, that was one of your OIC things. You were in charge of Wolverine Watchman, weren't you?
Yes, sir.
And Steve Robeson from Wisconsin. And he was at the FTX, wasn't he?
Judge, how is this part of order in terms of the admissibility of Exhibit 1?
Mr. Barnett, I'll limit the questions. Obviously, the attorneys will have an opportunity for cross-examination. This is limited simply to the exhibit.
Thank you.
Okay. Relative to the request for submission, Mr. Nunzio, let me start with you.
No, Judge.
Mr. Sauer.
As to its admission,
Yes.
Judge, we would object as relevance applies. First, this individual has created this proposed exhibit and has no personal knowledge of the 2 counts that are being charged in York County. And secondly, even the court had to try to arrange what this demonstrative evidence would show, as it was confusing to the court as well as to Mr. Nunzio and to myself, and I believe anybody else that would receive it. So with it not being a complete list, not being relevant, not being a portion of anything that this witness personally has knowledge of, and not being a complete list, we'd ask that it be stricken as a demonstrative piece of evidence. It was generated in anticipation of coming to court. Thank you.
Okay, Mr. Burnett?
I've had, some defects I asked to get looked at and they've been talked about on this exhibit.
Okay. Relative to the objection from Mr. Cyber, MRA 401 is the definition of relevant evidence. Relevant evidence means evidence having any tendency to make the existence of any fact that is a consequence of the determination of the action more probable or less probable than it would be without the evidence. MRA 402 indicates that all relevant evidence is generally admissible, subject to the restrictions obviously included in that rule. I understand the testimony thus far, especially in below, was the OIC, or sort of top of the umbrella, so to speak, in terms of this investigation. It sounds like there were many prongs, one of which involved the investigation into the events that brought us here today relative to the incident in Antrim County. This is a graphic representation of the subjects of his investigation as he has outlined that in his testimony. There were questions about 1 or 2 individuals that are not on it. In the court's mind, obviously, the attorneys can cross-examine relative to those individuals in that issue, but it would go to weight rather than inadmissibility. And so at this point, I will admit people's proposed exhibit number 1, but the objections are nothing for the record.
Thank you, Judge. With that in mind, can we publish that, please, Adam? Tell us a little bit about moving across in the top row, if you would, Mr. Impla, the individuals that are identified there.
Sure. From the top left, there's Barry Croft, so he's from Delaware. Second from the left is Adam Fox from Grand Rapids. Next is Brian Higgins from Wisconsin. Then we've got Mike Null and Bill Null. Then we've got Caleb Franks from Waterford, Michigan. Ty Garvin from Heartland, Michigan. So all the members up there, as well as Steve Robeson down here, they performed nighttime surveillance. And then moving along, well, through the middle, we've got Undercover Mark, we've got CHS Dan, and we've got Undercover Red represented graphically. Then down here, the founders of the Wolverine Watchmen, Joe Morrison, Pete Musico, and Paul Bellar. They're the first 3. Then we've got Eric Molitor, who participated in the daytime surveillance, and Sean Fix, who assisted him in the daytime surveillance. And then Steve Robeson. Steve Robeson was formerly an FBI informant out of our Wisconsin office, who became a double agent and started working with Barry Croft up here. And then on the far right is Amanda Keller, who is the fiance of Adam Fox, second from the top.
Okay, thank you. I want to draw your attention, if I could, to Exhibit 2, please, in your exhibit book. You told us a little bit about the different investigative techniques that you used during this investigation. And, Mr. Siver indicated that you don't have any personal knowledge. Is that correct?
That's not correct.
Okay, you told us about the different search warrants you asked for, is that right?
Yes, sir.
The things that came back for that. You indicated that you had some surveillance that you actually conducted, is that right?
Yes, sir.
Okay, you want to talk about that for just a little bit. When you have a confidential human source like Dan, who is, taking part in the daytime surveillance, what do you do? How do you monitor him?
So Dan's given a recording device and then a transmitter, and that transmitter transmits what's going on in real time live to me. So then I'm hearing what's going on with Dan as it's occurring. So for the daytime surveillance, the nighttime surveillance for these events, I'm responsible for Dan's safety And so for those times, I'm actually physically doing surveillance myself behind Eric Molitor and behind Mike Null and Bill Null as they're performing surveillance. I have prearranged words set up with Dan if he's in trouble, and a plan of what he can do and where he can go so I can help him if he's in danger. Same with our undercovers.
Do you have any ability to monitor their locations while this is going on?
Yes, sir. So there's the transmitting device. It transmits the audio live, but it also transmits the location. So on my tablet, I can look up the location of where the source or the undercover is as I'm listening to the audio.
Okay. Looking at exhibit number 2 there, can you tell us what that is?
So this is a significant events timeline. So these are 20 events throughout the case. They're not exhaustive. They're events that I selected that support the evidence in a linear timeline as it pertains to these subjects in Antrim County.
Okay. And where did you gain the information that's in proposed exhibit number 2?
So that'd be through live monitoring, through my surveillance, through the results of the search warrants, through interviews. These are some of the investigative techniques, but I compiled all of that information that I'm aware of as I created the exhibit book and put the timeline here to help guide and lead through.
Okay. Going to move for admission of exhibit or proposed exhibit number 2, please, Judge.
Mr. Nunzier?
Yeah, the exhibit's got some editorial indication in there with respect to uniting for a common cause and so forth. I don't mind the timeline, I understand the timeline, but, now we're eliciting evidence through an exhibit that's editorializing part of the timeline, and I think that's improper, Judge.
Can you point me to what you're referring to?
The significant events, the top portion where it says uniting for a common cause and mobilization for action. That's editorializing, Judge.
I see what you're saying. Okay. Any objection beyond that?
No.
Okay. Mr. Sykes?
Just the objections were placed on the record with the court, Judge.
Okay. Mr. Barnett?
Just a couple of questions if I could avoid here.
Sure.
The, starting with the first date where Mr. Molitor's name shows up, 518 American Patriot Rally, this is Mike No Fox Molitor. Were they together at that time, or they just were in the crowd somewhere, or what?
Judge, this is outside the scope of work here in terms of the
So
exhibit.
I think I know where Mr. Barnett's going with that.
Sure.
question, so I believe it's a proper first step for one here.
Okay.
Thank you, Your Honor. So, curious, were they all together? Because it looks like it on paper, I'm just asking if that is the impression you're
So
presenting.
when I created this exhibit, and my intentions were not to say they're all together, but I did learn during the opening that Eric Molitor had met with Adam Fox that day. So that was the first I knew of it. When I created the exhibit, I did not intend to say I didn't know, in fact, how they came to be there. I just know that all 3 of them were at the same event. I don't know how they coordinated it. None of them were known to me at the time of the event. They weren't under investigation at the time, to my knowledge. And so however they communicated and got there as a group, if they did or they didn't, all I know is they were all at the event. And that's what I tried to capture here.
Okay, that they were just present at the event.
To my knowledge, I know they were present at the event and that's it. I don't have any other information.
Response to riots, 531 Grand Rapids, St. Ben, Fox, Molitor, Bill Null, just present, not in the same group.
So I do have more information about that.
Hang on a second. So Mr. Barnett, the point was taken relative to the box for 518, but if we're going to keep going relative to the other boxes, the court was exactly beyond. So here, I understand what you're arguing just relative to the names.
Can I have just summarize what these names are, whether they're in groups or just present?
No, that goes beyond scope of the mission for the document. You certainly can do that during the cross-examination.
Thank you. I'm good with this one.
Okay.
Thank you.
And Mr. Nunzio, subject to their, Mr. Cyber, subject to the ones that we would filed previously with the court. Did I understand you correctly?
Judge, I have to state the record. This exhibit has been, it's not a piece of evidence. It is a demonstrative piece of evidence generated for the purposes of litigation. This is not evidence of a crime or evidence of not a crime, but But instead, Judge, the prosecutor would have to bring forth evidence of it, not just put it down on a picture. And this is not evidence. This is demonstrative that hasn't been proven. We'd ask that it be stricken.
Okay, Mr. Nunzio?
Nothing further.
Okay. Well, I certainly understand the point made by Mr. Seibert, but Agent Nicola has testified how he created this document, and certainly summaries or charts or whatever phrase we want to use as demonstrative pieces of evidence or exhibits are appropriate as long as the proper basis has been placed on the record. In the court's mind, it certainly has, based on his testimony. The court does take note Mr. Nunzio's commentary relative to the title, which is Significant Events. And so, Agent Nicola, just so that I understand correctly, the title of Significant Events, that's the title that you would place on this document?
Correct.
And then there are some lines indicating the phrasing uniting for a common cause and mobilization for action. Those are words and or the lines, the implications that you would place on there. Is that correct?
That's correct.
Okay. Well, the objections are noted for the record. Again, in the court's mind, those go for weight, not admissibility. Certainly, the attorneys can ask any further questions they wish on cross-examination, but I will admit people's proposed exhibit number 2. And once the exhibits are admitted, the parties may publish them. They don't need to ask us.
Thank you. Judge, can I approach the jury?
This is a handout paper.
Yes.
Yep, you certainly can.
Thank you. I just asked to take one and pass it down. Thank you.
Ladies and gentlemen, while you're doing that, I'll note from Mr. Ralston and the parties in general, I've communicated obviously to you all and the jury that we will wrap up around approximately 5 p.m. each day. What I would just ask is whichever attorney is questioning the witness, if you know that around that time, and I only mention it because we're in the last half of the 4 o'clock hour, as we approach 5 o'clock, if we reach a point where you think it's appropriate to stop, just let us know and then we'll take a break.
Fair enough. Thank you very much, Judge. And Judge, I'm also going exhibit number 1. I've got the handouts for the juries too. And thank you very much.
We'll take just a moment while they pass this. Okay, Mr. Wilson, go ahead.
Thank you, Judge. Agent Impla, you've got protests listed on the significant event timeline there. Is that correct?
Yes, sir.
Now, are protests illegal?
They are not.
Okay. And can you tell the jury a little bit about why you included them on there?
Sure. So in this case, as the subjects started coming together, they participated in rallies or protests where they used their First and Second Amendment rights, but they used it for recruiting and they used it to come together themselves. We talked about the 3 threat streams that started to merge together before they got together in overt planning for the attack. So what I did is I put those protests down and I described them as such, as the subjects used them and as they used COVID to benefit and use the rallies for their advantage.
Okay. The proposed exhibit number 3 in your book there, can you describe what that is?
Sure. This is Google Maps picture that I took off the internet of Michigan. And it includes a number of locations that I've typed in and boxed that are significant locations for the subjects in the investigation and the significant events timeline.
Now, Agent Empel, I got to stop you there for a minute. You said you were, I think you said you were from the UP, right?
Yes, sir.
Okay. I don't think the map shows all of Michigan, does it?
Well, the UP is kind of a different state.
Okay. Why did you put the different locations there on the map?
Well, some of the locations are the subject's premises or their house, their residence where they lived. The other locations are training grounds. And then I've got the 3 different locations for the governor where attacks were considered. So I've got the Lansing location or ceremonial office in Lansing or the governor's home. Then the Mackinac Island location, which is another governor's ceremonial location. It's a residence up there. And then finally, the other location here in Antrim County, which is where the final attack was determined to be.
Okay, I do notice there's one location in the state of Wisconsin, correct? And what does that show us?
That's Brian Higgins' residence.
Okay, and did he take part in either the daytime or the nighttime surveillance?
Yes, he came to Luther and he took part in the nighttime surveillance.
Okay, so I'm going to move for admission of proposed exhibit number 3, please, Judge.
Nothing.
Judge, I stand on my objection to relevance. It has nothing to do with the 2 alleged counts against my client.
Mr. Barnes?
No objection.
The court will admit people's proposed exhibit number 3. I believe that it is relevant and will assist the prior effects. We've been talking about a number of locations already. I assume that will continue. This witness prepared the document with the locations we have discussed, and I think that will be helpful for reference. So I will submission. People's exhibit number 3 is immediately used.
Okay, Plainwell in the bottom half of the mitt there. What's that location?
That's Mike Knoll's residence.
Shelbyville?
That's Bill Knoll's residence.
Munich?
That's the training ground and residence of the Wolverine Watchman. So it's the residence of the founders, Joe Morrison and Pete Nizico.
Belleville?
That's Sean Fix's residence.
Okay, Luther?
Luther is Wolverine Watchman training grounds. It's hunting property that's owned by Ty Garvin, and it was offered for the Luther FTX, the field training exercise.
And the governor's residence, is that the Birch Lake property?
Yes, sir.
Okay, I think the others are self-explanatory. Would you look at proposed exhibit number 4, please, Agent Empel?
I have it here.
Okay, and what is that?
So these are 2 pages. They're Google Maps pictures that I created with similar boxes and descriptions. And these 2 are specific. The first page is specific to Birch Lake. So it's the area, the pertinent areas around Birch Lake as a result of the daytime and nighttime surveillance. And then the second page includes the Birch Lake area, but it also includes Elk Rapids. So it has, it's kind of zoomed out.
Okay, the locations on page 1, tell us a little bit about why they're important to the case.
Sure. So there's 4 locations listed on page 1 around Birch Lake. The first one is the boat launch. So that's the area that Adam Fox, CHS Dan, and Eric Molitor reconned and determined that the group would be entering through the water to attack the governor's residence. And then obviously the governor's residence is located here visually. It's on Timberlake Drive. I've got a note here for Lake Michigan access. So that was the access point that Eric Molitor and Adam Fox and CHS Dan noted during the daytime surveillance. That would be an extraction point once they had kidnapped the governor. And then on the lower right here, there's a note that says apartments. This is it's apartments across the street from the Oasis Red Bull Tavern that Brian Higgins has identified as apartments that could be used as kind of a continuing safe house to get additional intel and do surveillance to find a pattern of life for the governor to help with the attack planning.
Say pattern of life, what do you mean?
Well, they wanted to know when she came, what the traffic was. Eric Molitor talked about conducting the attack during tourist season, so there's a lot of traffic. So what they needed to do was just get a little more intelligence to help with their attack planning.
Okay. Move for admission of proposed exhibit number 4, please, Judge.
Mr. Savage.
Stand in my objections.
Mr. Barnett.
No objection.
Okay. I again ask for People's Exhibit 3, court doesn't believe that it's relevant. Both maps will help orient the jury and the fact finder so that they can make a determination in this case, and on that basis they will be.
Thank you. And if you
And
can
they will be published. Yeah.
Judge, I believe that's exhibit 4.
Oh, I'm sorry if I misspoke, yes.
Yeah, 4. Yeah. Okay. Agent Ipley, we talked about 2 different surveillances of the governor's residence. One was during the daytime, I believe you mentioned. Is that correct?
Yes, sir.
And when did that occur?
That was August 29th, 2020.
Okay, and who participated in that?
That was Adam Fox, Eric Molitor, and CHS Dan.
Okay. In the second surveillance, when was that?
That was September 12th, the night of September 12th, 2020.
Okay. And did anybody in the courtroom today take any part in that surveillance?
Yes, Mike Knoll and Bill Knoll participated in that surveillance.
Okay. Let's back out for a little bit. We talked about CHS Dan being part of the daytime surveillance. Is that right?
Yes, sir.
Okay. Now, in terms of Dan and how you met him, can you tell us a little bit about that?
Sure. So I met him on March 17th, 2020. Dan had contacted a local police officer in Mount Morris Township. That's a small township near the Flint area where I was working, and had expressed his concern about the violence by the Wolverine Watchmen, which was a group he had just joined online. I was part of a local violent crimes task force, and I received a referral from Mount Morris Township police officers to reach out to Dan. They thought that the FBI might be interested in the Wolverine Watchmen. So I set up a meeting with Dan, and he provided consent for us to look at his phone, to see the messages on his phone, and then he intended to leave the group, but I asked him to stay in the group, to not leave the Wolverine Watchmen, because I was concerned.
I mean, why did you ask him to do that?
I was concerned about the level of violence and the fact that this group was organized. They had their own operational security, that's what we call OPSEC, and they seemed to be escalating towards violence. And I was concerned that the FBI didn't have any sort of coverage on them, and that an attack could happen before we could stop it.
Okay. When you met with Dan, I mean, what was it specifically that raised your concern? Was it something he said? Is something he showed you?
It was the encrypted chats on Wire. The Wolverine Watchmen had established a response code, so they would ping their location on Wire, and they expected a regional team to show up and attack law enforcement if that ping was put out on Wire. One of the vetting questions to be in the group was, are you willing to be considered a domestic terrorist? And then beyond that, the Wolverine Watchmen were talking about using the Onyx hunting app to track down property owned by local law enforcement so they could execute
Well, we do apologize for the interruption on some of our streaming services due to our 5 o'clock newscast getting ready to take the air. We are going to be not streaming right now across all of those services. If you wish to continue watching today's coverage from Antrim County, you can find it right now streaming on our website. It will stay there, upnorthlive.com. Our coverage from Antrim County will continue tomorrow morning across all of these services. Thanks so much for joining us.